What is your prayer?
Well, this matter may be fixed on 5th September.
Why?
Yeah, my lord, I've I on behalf of private respondent number 2. And I have also already
Have
filed
you
my,
informed the
yes,
petitioner's
my lord.
counsel?
I've already concerned with the petition, my lord.
Heard Mr. What is your name?
N. Rama.
Heard Mr. N. Ram, learned counsel for the respondent. Also heard Ms.
And
H.
again,
Lakshmi,
yes, Lordship. I am for state Lordship.
appearing for learned additional public prosecutor appearing for the state respondent. Learned counsel for the respondent prays for an adjournment on the ground of personal difficulty. He submits that he has informed the counsel for the petitioner side. Considering the submission, the prayer is allowed. Let this matter be listed again on
5th September. my lord.
5th of September.
Much obliged.
All right.
May I please, my lord? Lord, criminal petition, Lordship, I am going to file today, Lordship. Urgency is there currently as last item. I am praying for today list.
What is the urgency?
Case is, my lord, I am going against the Zimma application, whereby my in my account, Lordship, 37 lakh something was debited from my account as per order of the JMSC. Now they are going to another file another case. That is why, Lordship, serious matter. Kindly as last item.
No, what is the urgency? I don't see any urgency. This criminal petition is for quashing.
Against the order of the JMSC, 482 criminal petition, quashing of the JMSC order.
Which order?
Quashing of the JMSC order. Zimma petition. Against Zimma petition.
Zimma was granted.
Yes, in favor of our opposite party. They are going to file another application. That is why in that order, in our account, around 40 lakhs has been debited from our account. That is the urgency.
Okay, okay.
As last item, yeah. Oblast.
My Lordship. Lordship, I beg to mention item number 7, Lordship.
Yes.
Lordship, the conducting counsel, Lordship, Community Revised out of station, Lordship. So,
What is it? So what is your prayer?
Lordship, it may be listed after 2 weeks, Lordship.
What is your name?
K. Mena, Lordship.
K.
K. Mena, Lordship.
K. Heard Mr. K. Mena, learned counsel for the petitioner who submits that, who prays for an adjournment on the ground of personal difficulty of Mr. Omni Riba, learned conducting counsel for the petitioner. Considering the submission, the prayer is allowed. Let this matter be listed after 2 weeks.
Lordship.
Please, Lordship. Lordship, I beg to mention item number 16 on behalf of D. Panging. Lordship, the leading counsel, presently he is out of station. Matter may
On
be
behalf of the petitioner,
yes, Lordship.
have you informed the other side?
Yes, Lordship. Matter may be listed after 2 weeks.
Heard Miss, what is your name?
RC, and also, Lordship, item number
No,
When-
but let me pass order in
Okay,
this
okay.
case.
RC Lawangcha, Lordship.
RC Loancha, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. She submits that she has informed the counsel for the other side. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks.
No, Lordship, item number 23, Lordship. I have taken consent from the other party. Matter may be listed after 2 weeks. On behalf of D. Panging.
That is just on the implement petition. That way they allow, order may be passed.
Okay, then we'll take it up when the matter is called. You remain present.
Yes, Lordship.
We will pass the orders when the matter is called.
Item number 24 as well, Lordship.
24,
On behalf of D. Panging.
on behalf of
Deepanging.
Heard Miss R. S. R. C. Lo Chang, Loncha,
Lawancha.
Learned Counsel for appellant who prays for an adjournment on the ground that Mr. D. Panging, conducting counsel for the appellant, has some personal difficulty. Considering the grounds, the prayer is allowed. Let this matter be listed after 2 weeks.
Obliged.
Yeah, Lordship. I wish to mention item number 8, my lord. I'm on behalf of R. Sonar. The conducting counsel is out of station, my lord.
Sir, what is your name?
T. Darge ki.
Heard Mr. T.
Darge.
Tahe.
Darge.
Okay. Learned Counsel for the petitioner who submits that Mr. R. Sonar, conducting counsel for the petitioner, is out of station, and on that ground he prays for an adjournment.
Matter may fix after 2 days, my lord. That is on 21.
Prayer is allowed. Let this matter be listed again on 21st of August 2024.
There's one more item, my lord. Item number 25, my lord.
Yes.
Here also, my lord, matter may fix after 2 days, my lord. Senior counsel,
Same order.
obliged.
Yes.
Please, my lord. My lord, this is an anticipatory bail application.
You take the mic.
This is an anticipatory bail application, ma'am.
Yes.
My lord, I find the FIR at page number 14.
What is the accusation?
14 is the FIR, my lord.
14.
Page number 14.
Yes. What is the allegation?
Allegation is that, my lord, my father, I mean, the petitioner's father, my lord, he had executed a lease deed back in 2021 for running a petrol depot at Lumpur region, my lord. And it has been alleged that the father, along with the petitioner, has siphoned of all the money in regard to that petrol pump, which is kept in the case counter. And he has issued check without the permission of the leaser and fled the state. That is the allegation.
You have fled.
No, that is why, my lord. My lord, we can appreciate the fact that, my lord, I'm not privy to that contract, my lord. I am the son, my lord. My father who had executed that lease agreement, my lord.
No, but the accusation is against you that you took.
My father, along with his 2 sons. The item number 1 is a younger son, and item number 2 is a elder son, man.
No, lease deed is not in dispute, not the question before the. In the FIR, the allegation is that you took some money from the
Therefore, my lord,
pump.
and that has been done because the allegation is basically against my father, my lord. But running the petrol pump, my lord, it was run by my father, my lord. But I, as a son, my lord, out of courtesy, my lord, obviously at times used to help out my father, my lord, in running that business, my lord. But that, ipso facto, that would not mean, my lord, I'm involved in all these offenses, my lord.
Now, why are you apprehending your arrest?
Now, my lord, they have arrested my father.
Your father has been arrested.
And he has been released on bail, my lord.
He has been released on bail.
Yes, my lord. But
When?
then I have not annexed, my lord. I've just been informed, my lord.
Yes.
However, my lord,
Only allegation is that he has taken away money from the case counter and he has fled away. That is the only
But the
allegation.
main accused has been released.
Arrested and released.
Let him appear.
Right.
I forgot your name.
J. Sering, my lord.
J.
Sering. Tsering. Sering. T is silent.
Sherry.
Yes.
Heard Mr.
Opada, my lord.
Opada, learned counsel for the petitioner, also heard Mr. J. Sherry, learned public prosecutor. This application under section 482 of the BNSS has been filed by the petitioner, namely Mankesh Kumar Singh, who is apprehending his arrest in connection with Dumpori Poroji PS case number 3/2024 under section 381/34 of the Indian Penal Code. The gist of accusation in this case is that on which is the date of the affair, on
FIR, my lord.
5/6
5/6/2024, my lord.
2024, one Dei Nalo had lodged an FIR before the officer in charge of Dumporiji police station, inter alia, alleging that the father of the present petitioner, namely Shri Vijay Singh, had entered into a lease deed on 30/9/2021 with the informant to run the SR petrol depot at Dumporijo. However, it is alleged therein that on the night of 3/5/2024, the petitioner's father, along with his family members, ran away, fled Dumporijo after taking all cash and cash counters, cash from the cash counter. It is also alleged that the father of the accused persons misused the check. What is this accusation? Check leaves
Check leaves, my lord. The allegation is that
or
I have used the check leaf which was in the name of the petrol depot, my lord. And,
he has misused the check leaves which were in the name of KKK Marde filing station to acquire private loan without authorization or approval of the informant. Learned counsel for the petitioner has submitted that in the meanwhile, the main accused, that is the father of the petitioner, was arrested in this case, and he has already been released on bail. When
He was arrested on 6th June, my lord. 6th of June,
arrested on 6th of June
2024, my lord.
and when he was released on bail,
28th July,
and he
2024,
was released on by the trial court,
my lord.
released on bail on 20th of July. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR, as the lease was entered between the informant and his father only. It is also submitted by learned counsel for the petitioner that the petitioner is ready to cooperate with investigation. We can dispose it off.
It can also be here.
Stop. I have heard learned. I have heard the submissions. I have considered the submissions made by learned counsel for both the sides and perused the materials on record. As the main accused has already been released on bail, Stop. This court is of considered opinion that if the petitioner cooperates in the investigation, his custodial detention may not be necessary. Hence, the above named petitioner is hereby directed to appear before the investigating officer of Dumporiji PS case number 3/2024 and cooperate in the investigation within a period of 10 days from the date of this order.
I humbly pray, my lord, I'm staying at Bihar, my lord.
How much time?
2 weeks' time, my lord. That is.
Within a period of 15 days from the date of this order. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Damporijo PS case number 3/2024, the above named petitioner shall be allowed to go on bail by the arresting authority with bail of rupees 30,000 with one surety of like amount,
Obliged.
subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. You will cooperate in the
My
investigation.
lord.
With above observation, this bail application is hereby disposed of.
Obliged, my lord. My lord,
Who
item
is the
number,
other brother?
yes, my lord, the elder
Who is
brother.
also the same order. Name of the
Accused
petitioner would
will
be
be different.
different.
Abhishek Kumar.
Abhishek Kumar. Singh.
Obliged.
May I please, Lordship?
Yes.
Lordship, this is an application for quashing of the FIR charge sheet and entire proceeding arising out of Itanagar PS case number Lordship 355/21 under section 448 323 of IPC. Lordship, this petition has been filed by the accused persons along with the complainant informant who is also victim in connection with the same case. The petitioner number 1 is the accused person who is the wife of the petitioner number 2 and mother of the petitioner number 3. Basically, Lordship, the present dispute in the FIR has arisen.
Where is the affair?
Page number.
What is the allegation?
Allegation is trespass and simple hurt.
Sorry for interference, my lord. I suppose this petition would be hit by section 320 since to my understanding, both sections are compoundable in nature. my lord.
Lordship, yes.
Then why are you before this
That
court?
is it.
Lordship,
You can
yes,
approach the trial court.
Lordship, I have mentioned in para 11 of my petition that, Lordship, although the case is compoundable in nature, but Lordship, the accused person is residing at Pakekesang district as a
Where?
Pakekesang district government employee as a lower divisional clerk in the DC office. And petitioner number 2, he is also a government employee. He is working at Sagali. And the petitioner number 3 is a student studying in BA 3rd year at Government College, Doimuk. As such, Lordship, for invoking compounding application, all the accused all the persons, including the complainant and the accused person, they have to appear in the trial court for minimum 2 to 3 times.
Why 2 to 3 times?
Yes, Lordship. First of
You
all,
only need to file an application, my lord, under 320.
Only the person who is authorized to compound,
Hmm.
he
yes,
need to file an application.
the Lordship, for that also, Now the trial has not been, only the summon has been issued. Someone has been issued. Lordship, someone has.
You
been-
have advised wrongly to come to High Court. You could have advised.
Yes,
him
of course,
to
it
go-
is compoundable in nature, but if it can be it can be quashed on the interest of justice, Lordship.
No,
Yes.
quashing is not necessary in this case. In this case, if you file an application for under 320 or the corresponding provision of BNSS,
Lordship.
it would be compounded.
Yes, Lordship, but for that, my Lordship, with inability is that
What is the inability?
the accused person has to come at least 2-3 times before the trial court. First of all, 207 of the CRPC, earlier CRPC provision will be complied
Why?
for furnishing of the charge sheet.
CRPC or BNSS. At what stage compounding application may be filed?
So,
My lord, after, during consideration of charges can also be
If
filed.
trial begins,
yes,
then the permission of court
Yes,
is necessary.
yes. After.
Trial only begins after
After framing
consideration of
of
charges, my lord.
charges.
Yes, yes. So for consideration of charges, at least 3 hearing is
No,
required.
no, why to wait for that? You, on the first day, it will be compounded because.
Lordship, first the copy of the charge sheet will be provided. Here
No,
in this case, I have
no
obtained,
necessity of, we will direct
Yes, ma'am.
that you appear before the trial court. On the first day, it will compound.
Lordship, direction may
My
be
lord,
given.
even the direction is not
Direction.
required, my lord, since,
That direction is not required because that is the law.
yes, ma'am.
Lordship, but direction may be given, Lordship. Otherwise, the trial court will take at least 3-4 proceeding for
What is the corresponding provision under BNSS?
quashing.
Not quasi. 320.
Two 85, ma'am.
How much?
285.
285.
285.
No, it is not 285.
Lordship.
Provision corresponding.
359, ma'am.
359.
315.
Yes. What it means, 359 clause 5. Yes, Mr. Sherry. What it means,
When the accused has been committed for trial, ma'am,
what it
once,
means.
once the charge sheet has been filed, my lord.
So 359 clause 5 would be applicable only after framing
After-
of charges.
After filing of the charge sheet.
What this phrase
Committed
means,
for trial.
committed to for trial.
And that means, my lord, after consideration of charge, since trial
Yes.
begins only after CC. ma'am.
No,
And
it does not say that
Committed
after
for trial.
initiation of trial.
yes,
It
Lordship.
says
After
committed-
compliance of section 209, once the judicial magistrate first class has committed the case
But
for
that is applicable only in sessions cases.
session cases. ma'am.
In this case, it is not, it is summon procedure. Warrant
Yes.
procedure.
And Lordship, during the time of consideration of charge, if of course, in this case, there is no material of 324, which is again non-compoundable. But the trial court, on consideration of charges, if it founds that the section is non-compoundable in nature, so again, it cannot compound. As such, minimum, my submission before this honorable court is that on the first day, the trial court may not compound the case, even on the present, even on the filing of application, as because the court is not yet clear as to the section involved in the present particular
No,
case.
no, but the power of
Not-
five, this 528,
Lordship,
that is erstwhile 482,
is
can be
regarding the
accessed-
non-compoundable
may be
case.
exercised if other provisions are not there.
Lordship,
If you are getting relief by other provisions of the code, then why to invoke force?
So there's a remedy. under
yes,
that.
Lordship, since the provision is not clearly mentioned that compoundable case cannot be compounded. So I pray that for the ends of justice, since there is certain impediments for appearing before the trial court
No, no,
by
there is-
this.
There is no impediment. Otherwise, everybody will rush to.
Compounding of non-compoundable offense can only be done before the trial court. my lord. This
Lordship,
court
may-
cannot
gi-
compound the offenses, can only quash the proceeding. my lord. Compounding of non-compoundable offense can only be done by trial court under 320. That is the law.
Lords,
Compounding of,
Non-compoundable offenses can only be done by these. I mean, compounding of non-compoundable offense cannot be done. my lord.
yes. There is no impediment in
Yes.
compounding of compoundable offense.
Lordship, since they have already filed.
No,
This-
I'm giving you relief, but not before this court.
Lordship, direction may be given.
Third, Mr.
Titaba,
T.
Taba,
T. Taba, learned counsel for the petitioner. Also heard Mr. T. Sherry, learned public prosecutor for this state of Arunachal Pradesh. This application under section 528 of BNSS, 2023 has been preferred by the petitioners, namely 1, 2, and 3, praying for quashing and setting aside of proceeding of GR case number 728/21 of Itanagar PS case number, which arose out of Itanagar PS, ITA PS means Itanagar.
yes, Lordship,
Itanagar PS case number 355/21 under section 448/323 of the Indian Penal Code, pending before the Court of Learned Chief Judicial Magistrate, Capital Complex District, Capital Complex UPR. The facts relevant for consideration of this criminal petition, in brief, are as follows. Number 1, that on 11/8/2021, one Carbon Tau within bracket petitioner number 2 had filed an FIR before the officer in charge of Itanagar Police Station, inter alia, alleging that on that day at about 17:30 hours, Srimati Nyayir Loya and Srimati Kitpi Loya Prasad, within bracket petitioner number 1 against Nyayir Loya, petitioner number 1, came to the house of the informant and tried to forcibly take away the daughter of the petitioner, daughter of the informant. And when resistance was offered, the said Nyair Loya within bracket petitioner number 1 assaulted the informant, causing injury on her person. Stop. On receipt of the said FIR, Itanagar PS case number 355/2021 was registered under section 448/325/34 of the Indian Penal Code, and investigation was initiated. Stop. Ultimately, next para, ultimately on completion of the investigation, charge sheet was laid against the above, against the against whom?
Against petitioner number 1, Nyair Loya Tao.
Against petitioner number 1 under section 448/323 of the Indian Penal Code. Stop. Now, learned count, Mr. Teto Teba,
Yes.
learned counsel for the petitioners, has submitted that the trial court has issued processes summons to the petitioner number 1. However, in the meanwhile, there has been a amicable settlement reached between the parties, and therefore this instant criminal petition has been filed jointly by the accused, that is within bracket petitioner number 1, and the informant/victim within bracket petitioner number 2 and 3 for quashing the instant, for quashing the GR case number 728/21. Stop. Learned counsel for the petitioner has submitted that though both the provisions of law under which charge sheet has been framed, charge sheet has been laid, that is under section 448, that is section 448 and 323 of the Indian Penal Code, are compoundable offenses. However, the petitioners and the petitioners, petitioner number 1 and the informant/victim, who is the government servant?
Petitioner number 1 and 2, both.
Petitioner number 1 and 2 are the government servant, and they may have to appear before the trial court on more than one occasion to file an application for compounding the offense. Therefore, they have approached this court for quashing the GR case number, quashing the proceeding of GR case number 728/2021. Stop. On the other hand, learned public prosecutor has submitted that in the instant case, as both the offenses against which the charge sheet has been laid are compoundable in nature, there is no impediment for the petitioners to approach the trial court and file an application for compounding the offense. And this is not a fit case where inherent powers of the court under section 528 of the BNSS may be invoked for quashing of the proceeding 728/2021. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record. Stop. It appears that the offences involved in this case are under section 448/323 of the Indian Penal Code, which are and both are compoundable under section 320 within bracket 1 of the Code of Criminal Procedure 1972. And the said offences are also made compoundable under section 359 of the BNSS 2023. There is no impediment in the petitioners, mainly the petitioner number 2, that is the who is the victim / informant of the case, to approach the trial court and file an application under section 320 within bracket 1 of the Code of Criminal Procedure, 1973, for compounding of the offences in this case against the petitioner number 1. The apprehension shown by the learned counsel for the petitioners that the petitioners have to appear before the trial court on several occasions does not seem to be unfounded on facts. This case is a case where powers of court, where the appropriate provision for compounding the offense against petitioner number 2 appears to be section 320 of the Code of Criminal Procedure 1973. Hence, and this is not a case where the powers of this court under section 528 of BNSS may be invoked for quashing of the proceeding. Stop. In view of above, this criminal petition is disposed of with an observation that the petitioner number 2, who is the victim / informant of this case, may approach the trial court and may file an application for compounding of the offense against petitioner number 1. And as the offenses are compoundable in nature, if such an application is filed, the trial court shall order compounding of offense against petitioner number 2. With above observation, this criminal petition is disposed of.
Lordship, petitioner number 1 and 2. Sorry, 2 and 3. 3 is also victim.
3 is also victim.
2 and 3.
Petitioner number 2 and 3 shall have. I will make corrections.
Lordship. Deeply obliged. Item number 4.
Mayor Lordship. Mayor Lordship. Lordship, this is a joint petition filed by petition number 1, 2, and 3 for passing of FIR.
Washing of FIR,
Yes, Lordship.
498A.
498A, Lordship. It's a simple matter, Lordship. And they have settled the matter within the family member, which Lordship I have annexed in my, yes, and through a Kavang decision, they have
Where?
settled the matter.
Page number.
Page number, Lordship, I'll try, page number 50 is the type copy, Lordship.
It's too hot.
Page 50, Lordship.
Page 50.
Yes, 50.
What is this?
Lordship, this is an inter-village customary code or this. It's a village level Kavang, Lordship. Between that was a complaint was made by the petitioner number 2. That is the victim and the married, Lordship. It says, Lordship.
No, assuming a decision has been taken in Kebang,
Yes, Lordship.
whether criminal court can,
Lordship, in this way, this cover is to show that, Lordship, the matter has been solved, has been resolved amicably, resolved between the two family. That is the petitioner number 2.
you have the decisions where the non-compoundable offense can be. Have you brought any decision? There are decisions.
That I have not bought, Lordship, but since this is a Lordship after passing of Arunachal Pradesh Civil Code Act 2001,
Which court?
Arunachal Pradesh Civil Code Act 2021 has accepted, Lordship, that village level Kavang also to be a decision, a court decision, Lordship. So
No, that is okay. But in the criminal side, we are concerned with trial of offenses.
yes, Lordship.
So merely because the Kebang decision has been taken where compensation is awarded.
And Lordship,
Yes, Mr.
They
Sherry.
are bringing this on record only to show that they have settled the matter,
Oh, yes.
only that.
and Lordship, the section involved is a 498A, Lordship. Had it been other cases, that would have also been a different issue, but since
But
Lordship,
it is non-compoundable offense.
yes, Lordship, that's why I'm before this honorable court, Lordship. Had it been a compoundable Lordship, I would try it in the lower courts. But since this is a 498, it's a non-compoundable matter, Lord.
No, whether this court can compound non-compoundable.
No, only can quash the proceeding.
Yes, Lordship, I have come before this honorable court for quashing of that FIR, Lordship.
No, you show me an authority on which you are relying, that this court does have power to quash.
Yeah, Lordship, there are several effects.
Show me one.
Lakshmi, Lordship, I have not bought, but Lakshmi Narayan case.
You are not, you have not come prepared. I just wanted to point out that when you have come for quashing of the FIR,
Yes, Lordship.
at least you should have brought your arms and ammunitions.
That is their Lordship, but since this is a simple case, Lordship, 498A, it's a.
But therefore, I am
Narayan-
putting a simple query to you,
uh,
that why, how this court in exercise of its powers under 57482
Yes, Lord.
or 528
Yes, Lord.
may quash. What? It is because of some apex court judgments which says that in exercise of these powers,
Hmm.
where there is an amicable settlement, certain kinds of offenses may be quashed.
Yes, Lord.
Where is that judgment?
Lordship, it's a Lakshmi Narayan case in 2014. I have not bought the judgment, Lordship.
Bring that.
I'll pass over it for something. I'll get it and Lordship. I'll get it printed.
Today, all cases are of that nature only. You bring, I'll dispose it off.
Yes, Lord.
today itself.
Yes, Lordship. Well,
Take some time. We'll passing it over for the time being.
yes, Lordship. Well,
Item number 5. May I please, Lordship? Lordship, this is also an application under section 428 of BNSS for compounding, for quashing of the FIR charge sheet and proceeding arising out of the present GR case number 644/23 corresponds to
Here
Itanagar.
the offense was under 326.
Yes, Lordship. Lordship, basically, first of all, the FIR has been registered under section 324. There also is non-compoundable in nature. And the charge sheet has been filed in 324,
324
325.
or 326.
Later on, it has been converted into 326. As such, Lordship, this case is non-compoundable in nature. Therefore, I have filed this application before this honorable court on the basis of settlement between the parties, that is
Where
accused
is the
person,
settle, where is the settlement?
Lordship. Page number,
This is a joint petition.
Lordship, page number 39
No,
to,
same question to you.
Lordship,
any-
I have a judgment. Supreme Court case 2024, 6 SSC 466, Narendra Singh versus State of Punjab and others. Here in this case, the Honorable Apex Court has clearly given a direction that when the parties has came into a settlement and the court, this Honorable Court finds that if the proceeding of the trial court commence, there is a low chance of conviction, then for the ends of justice, settlement can be done, Lordship.
Which para?
Para 29. Para 29, para 13, para 8, para 12, those are the relevant paras. Lordship, para 29. In view of the aforesaid discussion, we sum up and lay down the following principles by which the High Court would be guided in a given acquainted treatment to the settlement between the parties and exercising its power under 482 of the code while accepting the settlement and quashing of the proceedings or refusing to accept the settlement with direction to continue with the criminal proceeding. Lordship, here in this case, even
No.
case of 307, which is considered as a heinous crime, has been quashed by the Honorable High Court, which is very serious in nature. So here in the present case, it's 326.
Yes. Anything?
Lordship, yeah, Lordship, this charge sheet copy is there, Lordship, where it was 325, Lordship, but there's no record whether it is converted to 326. So my Lordship, record may be called for, Lordship. In the meantime, if Lordship is satisfied, then it may be stay, Lordship.
No, assuming that it is 326.
Lordship.
Then
Lordship, it is Lordship, 326 Lordship is a injury Lordship. The injury report Lordship may to have to see Lordship, even though Lordship.
but we have to consider the question whether settlement
Settlement.
has been arranged.
Lordship, it is in Lakshmi Narayan Lordship, one paragraph is there Lordship, when both the parties are settled Lordship, because this is private in nature, if then it can be Lordship, past Lordship. In Lakshmi Narayan, it is there Lordship. Today I have not been Lordship. After some time, if it there Lordship, Lordship I permit, then I can bring it there Lordship.
Lakshmi Narayan is not cited here. No, where is the settlement?
Lordship, page number 39.
Otherwise, this is a joint application.
Yes, Lordship. Page number 39 of my petition, Lordship, may I read?
Lordship, actually 307 also, this, under Lakshmi Narayan, it can be Lordship, quasi Lordship.
Yes, yes.
307 also Lordship. Court has to see whether the Lordship, if they have mutually Lordship settled and they have Lordship, no any other grievances Lordship, then it can be Lordship.
Then we are disposing it of.
Yes, Lordship.
Heard Mr. Teto Teba Taba, learned counsel for the petitioner. Also heard Miss Lakshmi Hage, learned additional public prosecutor. This joint petition under section 582 of the BNSS, 2023 has been filed by the petitioners, namely Shri Devan Konya and Shri Tato Doyom, praying for quashing of the proceeding of GR case number 644/2023, corresponding to Itanagar PS case number 183/2023 under section 326 of the Indian Penal Code, presently pending before the Court of London, Chief Judicial Magistrate,
UPR.
UPR, Capital Complex. The gist of accusation in this case, no, the facts relevant for consideration of the instant criminal petition, in brief, are as follows. That the petitioner number two, namely Tato Doyam, had, on 17 August 2023, filed an FIR before the officer in charge of Itanagar Police Station against the petitioner number one, inter alia, alleging that the informant was assaulted by the petitioner number two and severe injuries were caused on the arm, back and other parts of the body of the petitioner number two. On receipt of the said FIR, the Itanagar PS case number 183/23 was registered and investigation was initiated. Stop. Ultimately, on completion of the investigation, charge sheet was laid against the petitioner number one under section
325
325 of the
IPC.
charges are framed.
326.
Charges are
Yes,
framed.
yes.
You have made a statement in your
Yes, yes,
petition where
Lordship.
325 of the Indian Penal Code. Stop. Learned counsel for the petitioner has submitted that the petitioner has appeared before the trial court and charges were framed on. Where is the statement? You have stated that
I have stated that Lordship.
326, but that is not the fact. Fact is 325 charge
Lordship,
sheet has
yes,
been
Lordship.
laid under section 325.
Charges has been, the charge sheet has been filed under 325,
Yes.
but charges has been framed under 326.
You have not made any.
I have
such-
not made Lordship.
Then
Yes.
how will we know?
That's why Lordship, records may be called for Lordship.
Because you have not made correct statement.
But Lordship, that is the fact, Lordship. 326.
No,
Because
that is the fact, but you have
the-
to plead.
Lordship,
Where have you stated?
that is there. Lordship, by reading the chart sheet also, it can be made out that the ingredients is 326 in nature.
No, we are not on that.
Lordship.
We are, statement of facts have to be correct. Charge sheet has been laid under section 325. Whether charges are framed or not,
Frame.
why have you not stated in your petition?
Yes, Lordship.
Suppose I quote you that council submits, and later on it is found to be wrong, then you will be in trouble.
Lordship.
So what should I do?
Lordship, up to the discretion of this honorable court, but charges has been,
No, I am ready to quash it,
Lordship.
but at least we have to narrate facts. And
Yes.
facts, there has to be some basis to narrate for that narration. And what you have stated in your petition does not tally with the records. Charge
Lordship.
sheet says it is under 325. You have stated it to be 326. Your oral submission is charges have been framed. You have not made any statement to that effect.
Lordship, it may be list after 2 days. I'll make a necessary amendment after 2 days. I'll do that. Fix date.
What will you do?
I'll make a necessary amendment to that effect regarding the pleading. That charge has been framed under section 326. That additional pleading affidavit I'll file regarding the pleading to the effect that, Lordship.
Not Miss so-and-so. Learned counsel for the petitioner has prayed for allowing the petitioner to file an additional affidavit to bring on record certain facts which may be necessary for consideration of the instant criminal petition. The prayer is allowed. Let this case be listed again on when?
After 2 days.
Suggest that date. Where is the calendar? On 23rd. On 23rd of August 2020.
Diploma.
All right, Lordship.
My Lordship, this is a joint petition being filed by it's petitioner number 1 and petitioner number 2. And petitioner number 1 is a husband of petitioner number 2, who is a victim in this instant case. So the brief, this is the,
Husband and wife.
yes. So since the section 498A is non-compoundable, that's the reason we have to move here. Otherwise, it could be compounded before the Honorable Learned Chief Judicial Magistrate.
You
UP.
have brought Lakshmi Narayan.
Yes.
You have brought any authority.
Yes, in this petition only, I had mentioned one case of this instant court only being passed based on the mutual settlement. Those type of cases can be, if suppose family nature, or can be quashed. So that's SCC 2022 SCC online Guwahati 962. It's in page number 8, paragraph 8. Page number 8, paragraph 8. So there was actually one more domestic violence case being filed by the wife in 2022 only, but that has been subsequently withdrawn by this wife only, and they had begotten 5 children. And then actually this wife, less educated, she doesn't know exactly what's there in 498A, since she thought that that's the same case. And that withdrawal and this disposal order is there in page number 20, Annexure C, by Learned Judicial Magistrate UPA. So dated 17/10/2022. It's there in page number 20. So now they are residing for last more than 2 years based on that mutual settlement deed.
You are residing together.
Yes. So
Anything? Heard Mr. Tanya Kipa,
yes, Lordship.
learned counsel for the petitioner, also heard Ms. L. Hage, learned. Am I correct?
Additional, yes, Lordship. El Hage, additional public prosecutor.
Yes. Additional public prosecutor. This application under section 482 of the code of, now you have to file under new provision or
Lordship, there is one order from this honorable court which has been referred to the larger bench. So it's still we litigator are in dilemma. So I don't know exactly status, present
But
status.
Lordship, other cases, they have filed under for 528 new law, Lordship. BNSS, they have filed, Lordship.
no, it has to be perhaps under new law because
Uh,
only pending applications have to be under the earlier law. There may be difference of views.
Yes, but I don't know, Lordship, it's a discretion of honorable Lordship.
But
And
482 and 528 are, nothing is changed, nothing has been changed.
yes,
Is
Lordship,
there
we,
any
yes, Lordship, we have filed 2 applications, but this had been listed for matter. We have filed one more, but that has not listed. But we have filed 2 applications, one for 528. If suppose there is a dilemma,
you
then
withdraw one?
no, Lordship, it's already, there is no any case in this case, actually. There was argument, so that's lead to the lodging of that FIR. Otherwise,
Under section
everything is,
482 of the Code of Civil Procedure, 1973. Code of Criminal Procedure, 1973, praying for quashing of GR case number 448/2022 under section 498A/323 of the IPC. Pending before the Court of Learned Chief Judicial Magistrate, Capital Complex, UPA. The facts relevant for consideration of the instant criminal petition, in brief, are as follows. That on (31/5/2022), the petitioner number 2 had lodged an FIR against her husband, namely petitioner number 1, before the officer in charge of Women Police Station Itanagar, inter alia, alleging that she has been subjected to torture, both physical and mental, by the petitioner number 2, that is her husband. On receipt of the said FIR, the Itanagar Women Police Station case number 66/22 was registered under section 498A/2323 of the Indian Penal Code, and investigation was initiated, stopped. On completion of the investigation, charge sheet was laid against the petitioner number 1. Under section 498A/323 of the Indian Penal Code. Now, by filing this joint application, both the petitioner and both the informant as well as the accused, that is husband and wife, have approached this court for quashing of the aforesaid case on the ground that they have reached a mutual settlement by executing a deed of settlement on 16/8/2022 and thereafter have been residing peacefully with each other since last 2 years. Stop. Learned counsel for the petitioners has submitted that the petitioner number 2 had also filed which case?
Domestic violence.
Where is the statement?
It's there in statement. It's there in paragraph 6. No, paragraph 5. Based on the mutual settlement deed 16, the petitioner has withdrawn the domestic violence case number 27, 2022.
Had also filed a domestic violence case. He had also filed a case under Protection of Women from Domestic Violence Act against her husband. However, after reaching mutual settlement, the said case has also been withdrawn. Learned counsel for the petitioner has submitted that the petitioners have 5 children out of their wedlock and they are residing with them now. And for sake of peaceful matrimonial life, this instant case, the pending criminal case against the husband is required to be quashed in view of the mutual settlement arrived at between the parties. Learned counsel for the petitioners has also submitted that the petitioner that this court would be well within its powers under section 528 of the code of 528. No,
Sorry,
under
Lordship,
482
482 I have come, Lordship.
482 of
Yeah, PCD.
Code of Criminal Procedure to quash a criminal proceeding where the husband and wife have already reached mutual settlement between them, and it would be futile to proceed with the criminal case pending against the husband. Stop. Learned additional public prosecutor also does not opposes the,
Lordship, it is
No.
after the discussion of court, Lordship, because Lordship,
no, but on the facts, you have no objection.
Lordship, as per the Lordship, new law, Lordship, new Lordship, any Lordship applicant, it may Lordship, under BNS Act, Lordship, as per my observations, as per my Lordship,
No,
understanding,
the
Lordship.
filing is wrong.
Lordship, filing this,
That,
Lordship.
that I will make an observation.
Lordship,
Learned counsel for the learned additional public prosecutor has submitted that this case has been filed, this criminal petition has been filed by the petitioner under section 482 of the Code of Criminal Procedure 1973. However, after coming into force of BNSS
528.
within bracket complete code, write the name of complete act. The correct provision ought to have been 528 of the
BNSS.
BNSS. However, it is also submitted at bar that this question has also been referred to a larger bench
Lordship,
as to which act would be applicable if the application is filed after coming into force of BNSS. In any view of the matter, since there is there any changes brought under 528 or same
Lordship, it's not same lordship.
as
Only
there is
passing by.
no change has been brought by legislature in 528 of BNSS and it remains as the provisions of 482 of the CRPC were. Hence, it does not matter as under which provision the court invokes its powers. Otherwise also, as on date, this court is of opinion that under section 528 of the BNSS, this court does have the inherent power to quash a criminal proceeding under such circumstances. Stop. In the instant case, as the parties are husband and wife, as in the instant case, as both the petitioners are husband and wife in relationship and they have mutually settled their disputes and also executed a mutual settlement deed to that effect on 16 August 2022. Stop. A copy of the said deed is also annexed along with the petition. Stop. Under above circumstances, this court is of considered opinion that it would be futile to proceed with the case, that proceed with the GR case number 448/2022 in view of the mutual settlement arrived at between the parties.
Matrimonial institution.
And as the dispute is also a matrimonial dispute between the parties. This court therefore allows the criminal petition and quashes the proceeding of GR case number 448/2022, which is pending before the Court of London, Chief Judicial Magistrate, UPR. This criminal petition is accordingly disposed of.
Highly obliged.
All right, lordship.
You found
Yes, Lordship, I've come up with the judgment Kapil Gupta versus State of NCT in Delhi. Lordship, in this matter, the case was registered under section 376.
in your case,
It's 498A, Lordship. It's a dispute between wife and husband.
Mr.
V
Item number
4, Lordship.
V Jamo.
Yes, Lord.
Am I pronouncing correctly?
Yes, Lordship. It's V Jammu.
Heard Mr. V Jamo, learned counsel for the petitioner, as well as Mr. T Sharing. Sorry, J Sharing. J Sharing spelling TS.
TSERING. T
Okay.
is silent.
Okay.
TSERING.
J Sharing, learned public prosecutor for the state of Arunachal Pradesh. This joint application under section, it cannot be under both.
I've with both, Lordship, 482 and 528. Stroke.
Okay, till the full bench decide this matter. I'm going by the 528 new section. That is my view actually.
And that is also the view of the Honorable Justice they was referred the matter for the larger bench,
But there must be some other view also, therefore it is there.
first coordinate bench. My lord.
Section 528 of the BNSS for what I have dictated. By Mr. Ikar Riba, Miss Karnam Riba, and Mr. Kengo Dirchi. Praying for. Charge sheet has been laid,
Yes, Lordship.
praying for quashing of the charge sheet number 35/2018, which has been laid in Women PS Itanagar case number 83/2018, corresponding to GR case number 552/2017 under section 498A of the Indian Penal Code against petitioner number 1, Mr. Ikar Riba.
No, again, petitioner number 3, Lordship. Petitioner number 1 is the complainant, the father. And,
Petitioner number 3,
uh,
Kengo Dirchi.
yes, Lordship.
Stop. The facts relevant for consideration of instant criminal petition are as follows. Are, in brief, as follows. Number 1, that on 1/9/2017, the petitioner number 1 had lodged an FIR before the officer in charge of Basar Police Station, inter alia, alleging that the petitioner number 1 has subjected the daughter of the informant, namely Miss Karnam Riba, who within bracket petitioner number 2, to cruelty. On receipt of the said FIR, the Women PS ITA case number 83/2018 was registered and investigation was initiated. Stop. Ultimately, on completion of the investigation, charge sheet was laid against the petitioner number 3 under section 498A of the Indian Penal Code. Stop. At what stage the case is pending?
Before Learned JMFC
At
UPI.
what stage?
At state of appearance, Lordship.
You have received summons.
Yes, Lordship, I have received the summon. Page 53 is your Lordship, the last order of Learned
Then
JMFC.
the counsel for the petitioner has submitted that after laying of the charge sheet, the case has been transferred to the Court of Learned Judicial Magistrate First Class,
UPI, Lordship.
UPR for
Yes.
disposal. And the said court has issued processes, has issued summons to the petitioner number 3. Stop. However, it is submitted that in the meanwhile, an amicable settlement has been arrived at between the parties. Any deed is there,
Lordship, there is no deed, only the,
statement is there.
only the statement is there and the covered decision between the
Oh,
both the
yes.
family.
Yes. Amicable settlement has arrived between the parties. In view of the decision of customary court, they, where the parties have, where the informant had approached for settlement of the dispute by order dated 25/6/2023. Since now, where are you staying?
Lordship, like the petitioner number 2 is working as an MTS in Arunachal Pradesh Secretariat Office. And the petition number 2 is also working here in the capital complex.
Where they are staying together?
No, Lordship, they're not staying together after the lodging of FIR, Lordship. So
Then
they have
how it
moved,
is amicably settled?
Lordship, they have moved on with their own life. The,
Okay, but they are not intending to pursue with the criminal petition, the criminal case.
yes, Lordship.
They don't, the victim does not want to pursue the,
Yes, Lordship. They don't want to pursue the victim and the father who has lodged the complaint.
learned counsel for the petitioner has submitted that in view of the settlement reached between the parties, the victim, that is petitioner number 2, as well as the informant, that is petitioner number 1, does not intend to pursue with the criminal case against petitioner number 3, and therefore they have filed a joint petition before this court for quashing of the matter. Learned public prosecutor submits that as this is a matrimonial dispute and as an amicable settlement has been arrived at between the parties, it would be futile to continue with the proceeding of GR case number 552/2017. Stop. I have considered the submissions made by learned counsel for the parties as well as peruse the materials on record, including the decision of inter-village customary court rendered on 25/6/2023. As in the instant case, the FIR was lodged by the
Father, Lordship, petitioner number 1.
father-in-law of petitioner number 3 and the father of the victim, that is petitioner number 2. And as both the petitioner number 1 and 2 have jointly approached this court for quashing of the charge sheet as well as proceeding of GR case number 552/2017. This court is of considered opinion that it would be that in view of the amicable settlement arrived at between the parties, it would be futile to continue with the proceeding of GR case number 552/2017. Hence, this is a fit case where the inherent powers of this court may be exercised under section 528 of BNSS for quashing of the charge sheet number 35/2018, as well as proceeding of GR case number 552/2017. Stop. In view of above, this criminal petition is hereby allowed and the charge sheet number 35/2018, as well as proceeding of GR case number 552/2017 are hereby quashed.
Deeply obliged.
Bail application.
Lordship, TCR was called for and it is awaited as per the office note.
At what stage the trial is pending?
Yes, trial, yeah, charge has to be considered because due to the non-filing of mandatory requirement, that's prohibited.
Scan copy of the trial court record was called.
Yes, Your Lordship.
It would be necessary.
It is not necessary.
No, but there is an order which
Yes.
implies that it is necessary.
Yes.
Therefore, there is an order.
Because yes, charge sheet was filed.
Where is the office note?
May I
What is the
conclude?
offense?
Offense is 384-507, 10 and 13 of the UAP Act. But
Okay,
for
it
UAP
will be
Act-
necessary.
It will be necessary, Your Lordship.
Heard, Mr. What is your name?
Devoke Devi.
D.K.
D.K.
Devri. D.K. Devri. Also Mr. T. Ete,
Yes.
Learned Additional Public Prosecutor. It appears from the office note dated 17/8/2024 that the scanned copy of trial court record which was requisitioned in this case has not yet arrived. Stop. Issue reminder for the same. Registry to issue the reminder. Let this case be listed again on
9th of September.
9th of
September.
September.
Oblige, Your Lordship.
Well, this is a kind of ichnusia or the mercy petition only. Although structured to be bail, you know. Well, what has happened? Is that the son of one of the accused, the coach and the student, you know, during course of
Records have arrived.
Yes, receipt.
Trial court.
I'll share
record.
receipt. It is in record.
Yes, Mr.
Then what had happened, my lord, by accident, my lord, the coach hit some vital point of the student who deceased, who died, who
Coach.
died. Yes. Then
Coach
there are,
means vehicle.
no, coach means that boxing coach.
Oh, okay.
So then what had happened was the coach was booked under 302, but due to lack of evidence, he was discharged. Then the parent of the deceased acted in the form of revenge, my lord. Then that after he was discharged from the court, discharged by the court in the trial stage, then the deceased parents killed
Coach.
the coach. My lord.
Oh,
Then in the meantime, what had happened was FIR was lodged again, and those people they were arrested, my lord. Here, this particular accused, my lord, this Tajay, my lord, he was not at the place of occurrence, my lord. Was at home only.
what is the name of the present petitioner?
Tana Tajay, my lord. This here, my lord, what happens on the authorization, my lord, the petitioner is the Joseph Tana, the brother of the accused, my lord. My lord, that principal bench and here something small difference is there, my lord. There normally it is the accused.
Yes.
So then, my lord, the alleged accused was arrested on, FIR was lodged on 30/10/2023. Then alleged accused was arrested on 13/11/2023, my lord. And since then, he is in incarceration, my lord. Now, my lord, that 161 statement has been recorded, my lord. Kindly come to page 29, my lord, 161 of the statement of the accused, my lord.
Of the bail application.
Yes, it's of the bail application. Not bail application. Page 29. हाँ ठीक है यही है हाँ मतलब हाँ
Just a minute.
a witness, my lord. The statement of one of the witness, Tanya, my lord. Tanya, my lord.
Yes.
And that's accused only. Well, it says
I Sri so and so, district so and so. I'm head Gangura of Paling village. On 30/10/2023, Sri Taji Tana came to my house at early morning before sunrise. He informed me that Sri Atam Tana, LS Janu Tana, and Sri Byate Tana had killed late Deva Taku at Sapa and requested me and Sri Ranka Tana to take both of them to Pakikesan police station. Milad. Both of them were ready. Accordingly, I and Sri Ranka Tana were ready with raincoat to take them to police station, but they did not come. I waited for them in my house, and Sri Ranka Tana had waited at the junction of Paling Road. On next day, Tajik Navam called me and informed that Atam Tana and Janu Tana, Byate Tana are in the house of Nar. But instead of going to the police station, they went down to the Nar again. So that means this alleged accused person was not on the spot, my lord. Only the charge could be the conspirator, my lord. The family, part of the family. Then here also, my lord, similarly in 164, my lord, at page
No, at
30, my
what
lord.
stage the trial is pending?
Trial
Evidence stage.
witness
Charges have been framed.
charges have been framed, examination of the
Uh,
witnesses are on.
How many?
Till
witnesses?
now, 14 PWs were already examined.
14 have been examined.
Yes.
Yes.
My lord, in the 160.
How many witnesses are there?
Actually, in charge sheet, there are only six.
Six,
But here,
Defense witness.
other defense witnesses and officer witnesses were not mentioned. In charge sheet, it is reflected only six, the main witnesses. But there is a MO and police officers. There are
Whether they have implicated,
My lord,
whether the witnesses have implicated.
yes,
that I
as
have not
per
seen.
record
It's
implicated.
conducted by
CCTV footage was there as per PW1, who collected the CCTV footage. And this lady was, one lady was seen with the deceased persons at that point of time, 11 point of time. And here, the accused is not charged with a 302. Here, accused is charged under 120B, criminal conspiracy.
yeah, 120B that I mentioned.
Main accused is,
No, just a minute.
Yeah.
Let him complete his submission.
yes, exactly.
So, my lord, 164 also, my lord, kindly see page 30, my lord.
130,
164 statement,
page
page 30, my lord.
30.
Yes, my lord.
Yes.
30,
Yes.
annexure 4, my lord. Consistently, my lord, will come to on oath, then paragraph, second paragraph, my lord, kindly come to fourth line, accordingly, fourth line, my lord. Accordingly, I and Sri Ranka Tana were ready with our raincoat to take them to police station, but they did not come. I was waiting for them in my house and Sri Ranka waiting at my junction of Pali. On next day, Tajik Nam called me and informed that Sri Atam Tana and Janu Tana Byate. So, my lord, this accused, my lord, 161 statement as well, my lord. Then 164 also consistently have been making a submission. Made the statement that he was not present on the spot. So maybe the police thought that they're part of the family member, so therefore they should also be booked under the booked as conspirator under 120B, my lord. So that sum and substance is that, my lord. And similarly, my lord,
How many accused persons are there total?
accused
Seven.
7 accused are there, my lord.
All are in jail.
All are in jail. No, my lord, some of them are released, my lord.
Harborers were released.
Huh? Two
Who
of them.
Harbor the accused.
Two of them.
Who are released?
That Navam was one
Out of-
Navam was
No,
released
on what ground they were released?
because for giving shelter to the alleged accused person.
Their charges were different.
Their charges were different. The same thing, you know, here these gentlemen also was not part in commission of the offense, but they were at the far away in the village, and then the police had that theory that they must also have evaded. But evaded and conspiracy are two different things, Mila.
No,
Because somebody,
no. Now we are not going into merit in detail.
I am not just trying to distinguish these two words only. I will not enter in bail matter. I cannot. It's only the question of law only. Whereas
And whether his custodial detention is required or not.
required or not, that recently, that took recent judgment is also there. That finally, Justice Oka's judgment, which very latest judgment, which says there my lord knows that only paragraph 21 it says well, let us go together that only that whatever grave the charges may be, bail is rule, jail is exception, my lord. They have finally restored that principle, my lord, para 21. Now, my lord, only question is, even if they are convicted also for charges of conspiracy, my lord, at the most, then but that will run concurrently with the principal section, my lord. There is no denying the fact. In that, even also, my lord, if they are convicted, then I have a time for appeal, my lord. So till such period, my lord, whether it really requires a person to be in the custody, my lord. My lord, kindly release them on bail, at least also have them fresh mind and trial, because still that even if the examination of the 14 witnesses have been done, then still I have the 313 and 318 stages are there. Then still that in the old CRP.
Where do you stay?
Yes.
Where is your house?
I have not made this a statement. But it's still just as a practice.
No, what is the assurance that you will continue to face trial? You will not flee?
I'll face, well, I'll not flee, because I have this. Kindly come. No, we have not done that,
Okay, okay. Yes, Mr.
I
forgot
para
your name.
11, para 9.
Yes, I have objection.
I forgot your name.
Here, this,
No, your name.
Jeetado.
Jeetado.
Yeah, Jeetado.
Additional PP.
Geetaro. Yes, what is your submission?
Yes, your lordship, on page 36. It's a charge sheet, part of charge sheet.
No, why do you require him to be continued detention?
Trial is at a verge of conclusion. Now almost all evidence were examined. More than recorded evidence were examined. So conviction, he was directly involved to help the accused to plead away from the stations, from the police clutches.
He helped the accused
And
flee away.
yes, to plead away from the clutches of police. And he conspired with the accused. He was indicted with a charge of 120B.
What is the evidence?
Evidence, it is narrated by the prime accused and co-accused.
No, that will not. Whether it will be of any use in trial.
Yeah.
What is the evidence against him? Any of the 16 witnesses?
Yes, other witnesses also stated
What-
that he
what-
involves.
What
To-
they have stated. Let us see. One of your main plea is that as the trial is near culmination,
Yes,
at this stage, bail may not be granted.
yes.
But why you need their detention now?
If this accused found not guilty, he will be acquitted only.
And if it is found, he is found guilty, he will face the sentence.
Correct.
Yes, what actually,
Why to keep them behind the bars?
why
now?
actually this bail matter has to be considered when trial is at the beginning or it is on the middle of the trial. But now it's a time for a conclusion of trial.
That is not correct submission.
Uh,
The
If your lordship, there is,
during trial,
if,
whether they are entitled to get bail or not.
if they are found,
If there is a threat of fleeing away, then they may not be granted bail. If there is a threat of influencing the witnesses,
yeah, exactly.
then they may not be. If no such threat is there, then why they should be put behind the bars during trial? There must be some reasons. What is your submissions?
Yes, 164 statement also disclose his name.
No, assuming he is involved, ultimately he would be found guilty.
Extrajudicial confession was there.
No, I am not on that. I am not going on merit. Assuming that ultimately it was found he was one of the conspirators, then he will face the punishment which is imposed.
Yes, this is charges. This charges under 302.
Do you fear that he will escape? He will not face trial? Whether any such fear is there?
Yes, he's a
On
resident.
what basis?
Yes,
What is the
level of
basis?
ordinance, yes, that is there.
What is the basis? If that fear is there, then I may reject the bail. But there has to be some basis for that. Merely because materials are against them, can it be a ground for denying the bail when he is not the main accused?
That is there.
Let him face remaining trial on bail.
Yes,
FSL report-
otherwise, merit is against this accused person.
FSL report also has not come, Lord.
Heard Mr. T. Tara, learned counsel for the petitioner, also heard Mr. G.
Tado.
Tado,
Tado.
Tado.
Yes.
G.
Additional-
Tado, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure,
Filed before the
1st July.
1st July. Lord.
439 of the Code of Criminal Procedure, 1973, by the applicant who is the brother of the accused, Shri Taje Tana, who has been detained behind the bars since 13/11/2023 in connection with SEPA PS case number 106/2023 under section 302/201/120B/34 of the Indian Penal Code, which is pending before the Court of London Sessions Judge West Kameng. It is Bomdila,
Bomdila, Lord.
Bomdila.
Session Judge Tawang District, Bomdila. The accusation in this case is that on 30/10/2023, one Dojin Taming, SI of police, had lodged an FIR before the officer in charge of SEPA police station, inter alia, alleging that what is NEDO means? NEDO?
My lord.
NEDO. Go to the FIR. The informants.
Oh, Dogin Tamin Nedo, my lord. Full name.
NEDO is name.
Yeah, Nedo is surname. my lord.
No.
Clan name.
NEDO is something else.
NEDO. Oh, NEDO. Well, this I don't know. This is new terminology I am also coming across.
Okay.
I'll ask.
Okay. What was the last line? Alleging that on that day he received on that day at about 6:30 hours, he received a telephonic call regarding finding of an unknown dead body near Type 3 Church Colony, SEPA. After receipt of the information, the informant rushed to the said place and recovered the dead body of a middle-aged person having blood spots on multiple locations on his body. Suspecting the same to be a case of murder, the FIR was lodged. On receipt of the FIR, SEPA PS case number 106/2023 under section 302/201 of the Indian Penal Code was registered and investigation was initiated. Ultimately, on completion of investigation, charge sheet was laid against six. How many accused were there? Six. Seven accused persons, including the accused, namely Taje Tana under section 302/201/120B/34 of the Indian Penal Code. Mr. T.T. Tara, learned counsel for the petitioner, has submitted that the petitioner has been detained behind the bars since the date of his arrest, that is on 13/11/2023, and he has been facing the trial by remaining in custody. Stop. It is also submitted by learned counsel for the petitioner that though only six witnesses were listed in the charge sheet for the prosecution side. However, in the meanwhile, the prosecution side has already examined 14 witnesses and 14 witnesses. Stop. Therefore, there is no apprehension that witnesses may be influenced if the present petitioner, if the accused Taje Tana is released on bail. Stop. Learned counsel for the petitioner has also submitted that it has also come up in evidence that the petitioner was not present at the place of occurrence, and the only charges against him is as a conspirator. Stop. Learned counsel for the petitioner has also submitted that in the meanwhile, 2 out of 7 accused persons who are facing trial have already been released on bail. And he submits that the accused Taje Tana would face trial and cooperate in the remaining part of the trial if he is released on him behind the bars.
Para 11, I have given the undertaking.
Stop. On the other hand, Mr. G. Tado, learned additional public prosecutor, has opposed the grant of bail to the on the ground that there are sufficient incriminating materials
I got it, Milord. Night emergency duty officer.
Night emergency.
Duty officer.
Oh,
NDO. Yes.
NEDA.
My brother-in-law is SP, so.
Sufficient discriminating materials against Shri Taje Tana are there on records. He also submits that as the above named accused is one of the main conspirator in commission of the alleged offense, and as the trial is nearing its culmination, and there is every likelihood that the above named accused would be convicted in the trial, bail may not be granted to the aforesaid petitioner. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including which was requisitioned in connection with this bail application. So in the instant case, already two of the co-accused who are facing trial have been. Moreover, it appears that though only 7 in the charge sheet, prosecution side has already examined 14 witnesses.
Yes.
Therefore, the apprehension of
Same.
influencing the witnesses at this stage does not arise. Stop.
Yeah, no.
Though an additional public prosecutor has also submitted that he apprehends that the accused may escape the course of justice if allowed to go on bail. However, no basis for the said apprehension is there, could be brought on. Considering the facts and circumstances of this case, as well as considering the submissions made by learned petitioner, that the petitioner is ready to cooperate in remaining part of the trial, this court is of considered opinion that there is no justification for keeping the above named accused behind the bars during remaining part of the trial when he is not one of the main accused. Stop. In view of above, also considering the fact that the accused Taje Tana has been detained behind the bars for nearly 10 months, more than 10 months, and trial has fairly progressed. Stop. This court is of considered opinion that this is a fit case where bail may be granted to the accused named above. In view of above, Shri Tajetana is hereby allowed to go on bail of rupees 30,000
Yes,
and also
with strict conditions that
with one surety of like amount to the satisfaction of learned
session court.
trial court. Which court?
Session court.
Learned Sessions Court to the satisfaction of learned session judge, comma, Bomdila, with following conditions. Condition number 1. The petitioner shall, the above named accused, namely Tajetana, shall regularly appear before the trial court and shall cooperate the trial. Stop. The petitioner, the above named accused shall not directly or indirectly make any inducement, threat, or promise to any of the witnesses or any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts before the trial court. With above observation, this bail application is hereby disposed.
Next item, wife. Same case.
Whose wife?
Taj's wife.
Arising out of same
Same,
FIR.
same. Only name, she was arrested on the same charges on 27/11.
Who is the petitioner here?
Here, my lord, Amutana, my lord.
Heard Mr. T.T. Tara, learned counsel for the petitioner, also heard Mr. G. Tado, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Amutana. What relationship he has?
This thing, sister,
Sister or sister?
sister-in-law.
For release,
Here, Your Worship, this wife, this accused
Wife of the.
had
accused
prior
Tajay.
knowledge of preparation of the killing.
what?
And section 34 is also there with, along with 120B.
Okay. She is also conspirator,
Yes.
Yes, 120B
but in,
/ 34.
okay, I learned that.
Facts in the previous bail case were same. Only name has to be changed. There's no.
Keep as it is. Wherever changes would be required, I'll make changes.
Correct,
Name, you give me the draft, I'll make changes.
right. Much in this.
Same
Okay.
condition, 30,000 with one surrender.
Correct.
Knowledge.
Please, Your Lordship, my lord, this matter has been is being listed for the first time, Your Lord. For the second time, the earlier the Honorable Mr. Atta was
Well, this matter is pending due to, Your Lordship, there is an issue regarding the maintainability, whether it has to be invoked under BNSS or the CRPC, and that has been referred to the larger bench by the coordinate bench, Your Lordship.
Now, till larger bench decides what would be the fate,
Sorry, Your Lordship.
till the issue is decided.
Issue is not, Your Lordship,
No,
but the coordinate bench, which,
that means there are two decisions now,
yes, Your Lordship, the earlier will be followed, Your Lordship.
two decisions.
Yes,
Why earlier should be followed?
Your Lordship, as per the,
If earlier is found to be wrong.
Your Lordship, this is the earlier order. Your Lordship, I am not saying, Your Lordship, the CRPC or BNSS will follow. Your Lordship has lightly pointed out in one of the matter. If there the provisions are same, a case is pending register prior to the coming into implementation of the new code, then Your Lordship, the either BNSS or the CRPC would be invoked at this stage because it's a transition stage, your lordship is very aware. And so far as your lordship, some provisions are concerned.
In some provisions, there are some changes.
Yes, even in anticipatory bail, your lordship. In new BNSS, your lordship, in anticipatory bail, that a the interim portion has been, no, is not there, your lordship. In 482, your lordship will find in 482 of BNSS
482,
of the BNSS, your lordship, which is the corresponding section of 438.
okay, we'll continue.
Yes, your lordship.
We'll continue this discussion
Okay, your
at
lordship.
2. 2 will continue.
Okay, your lordship.
My lord, since Justice Kadak had differed from the earlier judgment passed by Justice Habung, your lordship, may I pray that in this matter, your lordship, case diary may be called for your lordship. We are praying for calling of the case diary, your lordship, in this case, and then even though your lordship can still invoke your inherent power, your lordship, under 528 and of the BNSS Act, your lordship.
Okay, you have filed the application under 439.
439 as well as under the new Act, your lordship.
Plain safe,
Yes, your lordship.
Yes, yes.
but what is your submission?
Your lordship, is your lordship, I have said that no doubt that the judgment of the coordinate bench was doubted by the coordinate bench and has been referred to the larger bench. But your lordship, there is no any interim order from the larger bench staying the operation of that order. And your lordship, it is well settled that when there is a conflicting,
What was the reference meant?
yes,
What
your
was
lordship,
the issue?
whether which provision of the, whether it should be invoked under BNSS or the CRPC when the matter is pending prior to the implementation of the new Sanhita.
No. Because now most of the matters are pending.
Yes, your lordship.
So while filing an anticipatory bail application,
Yes,
whether new provision would be applicable
or the
or
old.
old
Yes.
provision will be applicable in case of those cases which were filed prior to 1/7/2024.
Now, which were the main case, which main proceeding is pending prior to the implementation, but the application which has been filed after implementation. Your lordship, I'll be very brief, your lordship. The reference was made to the cases which were pending, investigation, supposedly investigation is pending prior to the implementation of new code. But after the implementation, if anticipatory bail is filed or 482 application is filed, it has to be filed under which provision of the Sanhita or the code? Under which code or Sanhita?
Now, what is your submission?
My submission, your lordship, if your lordship allow, your lordship, I would like to, your lordship, point out some provisions. I will directly come to the, your lordship, the provision of bail first. Your lordship, for that we have to compare both the Sanhita and code, your lordship. What are the substantial changes?
This is a bail application, no?
Yes, your lordship.
It's a bail application.
Okay. Four 83.
Yes, 483. Regular.
Yes. Yes.
Now, your lordship, here, your lordship, while considering the provision, we have to read the provision as a whole. So now, the 483 says, special power of the High Court or the Court of Session regarding bail. Now, it is an admitted fact that the offense has been registered under IPC, your lordship. Offense has been, your lordship, registered under IPC, and the classification of the offense has been given by the schedule of the CRPC of the IPC, not under BNSS. And if it is to be invoked under BNSS, it has to be corresponding with the BNS. Because the section 4 of the BNSS doesn't include the IPC, your lordship.
Okay.
Here in your lordship, we'll see in the subsection, your lordship, proviso also, your lordship, provided the High Court provided that the High Court or the Court of Session shall give before granting bail to the person who is accused of an offense which is tried exclusively by the Court of Session or which doth not to trial is punishable with imprisonment for life, give notice to the applicant for bail to the public prosecutor unless it is for the reason to be recorded in writing of the opinion, it is not practical to give such notice. And second, your lordship, provided further that the High Court or the Court of Session shall, before granting bail to the person who is accused of an offense trialable under, your lordship, here your lordship will find
It uses BNS.
65. Yes, it uses BNS, your lordship.
So it cannot be made applicable to IPC.
Yes, your lordship. Why I'm saying so?
That is your logic.
Yes, why I'm saying so, your lordship? Because the IPC is a substantive law, and no doubt the CRPC and BNSS are the procedural law. The procedural law will have a retrospective effect unless it is specifically provided by the legislature. So now, your lordship, whether it has to be given.
Okay, understood. Similar logic will be applicable in case of anticipatory bail also.
Yes.
Where section 4 says there is a bar. Section 4 of the 438.
Yes, sir.
Subclause 4 of the 438.
Yes.
Which says that 376(3) there is a bar.
Yes.
But in new provision 376 is not used.
Yes, your lordship. Other provision of the BNS.
Corresponding provision of BNS has been used.
Yes, your lordship.
So how we will apply new law, new procedural law to the old code?
Yes,
in
your-
cases?
yes,
That
your-
is one difficulty.
Yes, that is one difficulty. And secondly, your lordship, what I'm trying to point out, your lordship, the decision which has been rendered by the coordinate bench, what difficulty has come up, your lordship, in that case? Actually, the offense
Which
was
one, first one or second one?
first, your lordship, the first one, where it has been settled by the coordinate bench that if the offense is committed prior to the, if the FIR is registered prior to the implementation, then subsequent any application or any remedy in relation to that offense will be under old code because the saving clause 531 saved that old code, your lordship. Now, what has happened exactly in that case, your lordship? The case was registered under section 354A of the IPC, which is bailable. But since the petitioner has invoked the BNSS after implementation, he has given the corresponding section of that 354A, which is non-bailable now.
Then it appears that old law would be applicable.
Yes, your lordship.
There seems to be some logic.
Because section 4 clearly says, your lordship will see the
What
section.
will happen in case of 482 and 528?
Your lordship, 482, again, your lordship, here the issue is, your lordship.
But there no such issue like, because 482 recognizes inherent power of the court
Yes, exactly, your lordship.
to pass certain orders.
Yes,
Same language has been used in 528.
yes,
So in that case, new law would be applicable, perhaps.
yes. But here again, your lordship, in 482, your lordship will find the give effect to the order of the Sanghita. It doesn't say code.
Oh, yes.
It has to be looked
That
into.
is the difficulty.
It says Sanghita, not code. No doubt this honorable court has inherent power, no doubt. But the saving clause itself provides that Sanghita, it doesn't use word code. Otherwise, the legislature would have used the code or Sanghita.
Or Sanghita.
Yes.
And, okay, then there is some difficulty.
And your lordship will also, the morning this compounding of the offense was there. If your lordship, the BNSS is applied, then your lordship, the table of the BNS has to be looked into, the schedule 1.
Yes.
Then
320, in case of compounding, I was thinking inside the chamber, in case of compounding, if the offense is before coming into force of BNSS,
Yes, yes.
320 would be applicable.
Yes,
Not
yes,
the corresponding new provision.
yes.
If the offense is, because the section 320 specifically mentions
Yes.
which offense.
Which offense?
And in the new code, new BN Sanhita, offenses are under different provisions.
Provision and be a different is a BNS itself, your lordship,
Yes.
different, and it has his own its own classification.
Therefore, it appears that in some cases, though if we read 531, you read 531.
Yes, your lordship. 531 repeal and saving, your lordship. May I read, your lordship?
Yes,
The Code of Criminal Procedure 1973 is hereby repealed.
repeat.
Notwithstanding such repeal, if immediately before the date on which the Sanhita come into force, there is any appeal,
Yes.
application, trial, inquiry, or investigation pending, then such appeal, application, trial, inquiry, or investigation shall be disposed of. Your lordship, pending has to read along with the word dispose of, continue, held or made as case may be, in accordance with the provision of Code of Criminal Procedure as in force immediately before the commencement, herein refer as the code, as if this Sanhita has not come
Shall
into
be
force.
disposed of. Pending shall be disposed of. Continued. As the case may be. Okay.
And your lordship, there was a confusion
Then
in one
it
aspect.
appears that all would be applicable.
Yes, now your lordship, in the reference, there was a confusion, one more confusion was this application, term application.
Okay.
Now your lordship, on that your lordship, my humble submission would be, your lordship, this stage which the legislature has indicated in the saving clause, this is the stage of a sole proceeding. All the proceedings are, these parts are independent but interlinked with each other. Your lordship, when investigation is being conducted, inquiry, trial, appeal, it is not come into the picture, your lordship. When investigation is complete and charge sheet is filed, then the inquiry stage commences, inquiry stage. Then there is no any question of investigation. However, if it is the court, if there is an order for further inquiry, further investigation, then even in the stage of inquiry, there will be a investigation when we constitute, your lordship. Now, during the trial, until or unless charge is framed, trial doesn't commence, your lordship. And now, after trial conclude, but your lordship, it has been held by the Supreme Court that the trial is deemed to be the continue of the appeal is deemed to be the continue of trial. Now, your lordship, this term application come in between appeal and trial. Now, your lordship, the collocation of this application term, that has to be considered because there is, your lordship, one judgment of the Honorable Supreme Court where Supreme Court has given stress on the collocation of the term application. This
What it says,
your lordship,
what it says.
may lordship, this is the judgment of the
So
Honorable
you
Supreme.
read the relevant portion.
Yes, your lordship. 7 and 8, your lordship. Because there, I'm trying to project that this cannot be application, it cannot be made applicable in all the applications. What I'm trying to submit is, your lordship. Now, your lordship may come to
Now
para.
it speaks about pending applications.
Yes,
It saves only pending applications.
yes, your lordship.
Suppose application was filed before 1/7,
Yes,
then it will continue. If it is filed under 439, it will continue under 439.
yes,
But it does not speak under what provision new application would be filed.
yes, your lordship. Yes,
So normally the approach would be normally that if a new act is there, application has to be under new law,
yes,
unless and until some rider or saving clause is there.
yes, your lordship. That was the, your lordship, that was the view of the coordinate bench, which says every investigation has to be carried out, no doubt has to be carried out under CRPC. But when you come file an application, it has to be under BNSS. That was the observation, your lordship, by the
Of the second
second one, your lordship, which defer the first, your lordship. Now,
then there may be some difficulties.
yes, your lordship. Now, your lordship, what I'm trying to indicate here is, your lordship, when investigation, your lordship, it's a procedure part. trial is trial, your lordship. The CRPC and BNSS are the procedural law. If your lordship,
No, I'm just putting a query. Suppose an investigation was completed before 1/7/24. Charge sheet was laid before 1/7/24 under section 448 and 323. And the victim says that I want to compound. Now new provision is under something else.
yes,
Say 500 something. Old provision is 320. Then it is, he has no pending applications.
yes, your lordship.
Question is under what provision he will file an application?
Yes,
Normal idea would be he will file under a new
yes, your
new
lordship.
code. But if he files under new code, there will be some complications because new provision does not mention anything about old IPC.
Yes, your
It
lordship.
mentioned about Bharatiya Nyaya Sanhita only.
Yes, your lordship.
So 448 is not there in new provision.
Yes, your lordship.
323 is not there. Some
Yes.
other section has been.
Yes, inserted, your lordship.
So for compounding, you have to file application under 320 only.
320 only, your lordship. Why I'm saying so, your lordship? Your lordship, the pending word pending has to be read along with the word dispose of and continue. Your lordship, dispose of term means is finality, your lordship.
So everything will continue as per the
All
old act.
all code. According to your lordship, my understanding, your lordship.
That may be. Otherwise, we may face practical difficulties.
Yes, your lordship. Practical difficulty will be there.
In
Ambiguity will be there.
Many areas. In some areas, it may not be there.
At not this stage, but on the later stage, your lordship, there will be lots of difficulty, your lordship.
Unless this clarity is there.
Yes, your lordship.
Okay. Now, why you were showing this?
Your lordship, why I'm saying so? Because your lordship, this term application will not have a general application in all the petitions, your lordship. Basing on that, your lordship, I'm just trying to indicate the Supreme Court has given the stress to the collocation of the word application.
Where, in which para?
The para, your lordship, may directly come to 8, your lordship. Operating para 8.
Okay.
May I read, your lordship?
Yes.
Your lordship, and 484 is the corresponding section of the BNSS, your lordship.
Yes.
It will be seen that the word application in the saving provision contained in the clause A of subsection 2 of section 484 immediately follow the term appeal. It therefore takes some color from the collocation of the words in which it occurs. It is synonymous with the term petition, which means a written statement of material fact requesting the court to grant the relief or remedy based on those facts. It is a peculiar mode of seeking redress recognized by law. Thus, considering there can be no doubt that the word application as used in clause A of section 484 of the Code of the 1973 will take in a revision application made under section 435 of the old code. Such a revision application does not cease to be an application within the purview of the aforesaid clause A, merely because in the event of application being allowed, the session judge was required to make reference to the High Court under 438. Whether such an application is granted or dismissed by session judge, he finally disposed of the matter so far as his court is concerned. Maybe that a purely interlocutory application in a pending action, which by itself is not an independent mode of seeking redress recognized by law, is not covered by the word application as used in the aforesaid clause A, but it is not necessary to express any final opinion. No doubt, your lordship, final opinion has not been given, but doubt has been created by the Honorable Supreme Court that whether it will applicable to the interlocutory application of the interlocutory nature or not, your lordship.
The application word used in 531.
Yes, your lordship.
Okay. Now, in this case, the petitioner has prayed for bail.
Yes, your lordship.
Bail in a case which was registered prior to 1/7.
Yes, your lordship.
They have filed the application under 439.
Yes.
As well as mentioned 483 also.
Yes, your lordship.
Now, where is the difficulty in this case?
No difficulty. 439, so far as
We
439.
will treat it as a petition under 439.
Yes, your lordship. That can be
The
done.
question, that was the question which has been referred to now.
Yes, your lordship.
Whether after coming into force of BNSS, whether we can continue to accept application under old law. or not.
Yes.
But the word that if there is a pending investigation or trial, it shall be disposed of or continued as per the old law.
Yes, your lordship.
Then it appears that the provisions of old law would be applicable.
Yes, your lordship. And that is the judgment rendered by the earlier coordinate bench, your lordship. Because your lordship, this difficulty will come because these are procedure interlocutory application if it is invoked under
Okay,
this.
then let us, in this case, we call for the case diary.
Yes, your
taking it
lordship.
to be a 439 application,
Yes, your lordship.
though they have mentioned both. Okay. Any submission?
No, your lordship. My lord, your lordship can still invoke, your lordship in her power under 528, your lordship, and along with, it can be read along with the,
528 in a bail application.
yes, your lord, my lord, Delhi High Court has, your lordship, the Honorable Delhi Bench High Court has also invoked the same powers, your lordship.
Why?
Since it was an application, it was an anticipatory application filed under.
No, but there are provisions in the code.
Yes,
Either you have to choose whether old code or
New code.
new code. You cannot go to a third provision.
Yes.
That is 528.
So lordship, only to avoid if, to not result in delay or, in taking up the application, your lordship.
Yes,
That
now
is why the-
we are taking it up
Yes, your lordship.
without mentioning anything about reference.
Yes, your lordship.
I am treating it to be an application under 439.
Yes, your lordship.
But same may not be case. Oh, in 482 also you have pointed out 528 of this Samhita.
Yes.
That language is there, na?
483.
483, your lordship.
No. The corresponding provision of 482,
528, your lordship.
528.
Yes.
What is?
528, your lordship. The saving inherent
Saving
power, inherent
High
power.
Court.
It says nothing in this Sanhita
Yes.
shall be deemed to limit or affect the inherent power of the High Court to make such other orders as case may be necessary to give effect of any order under this Sanhita. He said this Sanhita, your lordship. Sanhita again, the word
So it
Sanhita.
will be applicable only in those cases where Samhita is applicable.
Yes, your lordship.
If as per 531 old code is applicable, then 482 has to be applied.
Yes.
In that Lakshmi, your case, I will change the order. It has to be under 482. If the matter is pending before coming into force of the act, it has to be 482. That is tentative observation without saying anything about the reference.
Yes.
Finally, it will be decided by the
Yeah,
larger
bench.
bench.
Yes, your lordship.
We are treating it to be an application under 439. Is it okay?
Yes, your lordship.
Miss, what is your name?
D Tamuk, your lordship.
This is item number
12. 12.
D.
Tamuk.
D. Tamok, learned counsel for the petitioner. Also heard, I forgot your name.
Theatre. Theatre.
Oh, yes, T8. T8, learned additional public prosecutor.
Yes.
Additional,
Yes, additional. your lordship.
additional public prosecutor. This application under, what was the earlier order? Because of reference.
Yes.
In this application, the petitioner has mentioned both section 439 of the Code of Criminal Procedure, 1973, as well as section 483 of the BNSS 2023 in the cause title of the said application. It also appears from order dated 14/8/2024 that there is an indication that a reference has been made in connection with similar applications to a larger bench regarding the applicability of provision under BNSS 2023 or under Code of Criminal Procedure, 1973. While filing an application for bail in connection with offenses where the FIR was lodged prior to coming into force of BNSS. As the petitioner has quoted the relevant provisions of both BNSS 2023 as well as Code of Criminal Procedure 1973 in this case. And as this matter relates to bail concerning the liberty of the petitioner, pending the outcome of the larger bench in the reference, this court is inclined to treat the instant application under section 439 of the Code of Criminal Procedure 1973. It appears that the offense involved in this case are under section 342/325/307/365/34 of the Indian Penal Code, and the accused has been detained behind the bars since 18/6/2024. This court is of considered opinion that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing
29 of this month.
29, Your Lordship.
29.
Yes, Your Lordship.
Fixing 29/8 for case diary.
Much obliged, Your Lordship.
Deeply obliged.
Please, Your Lordship.
What is this?
This is application for delay of condemnation.
Condonation of delay. Notices are served
Notices are served, already served
on all.
Respondent.
How much delay is there?
Delay, Your Honor, Your Lordship, 138 days from the date of passing the judgment and award.
Where have you explained the delay?
Yes, Your Honor.
Which para?
Yes, sir.
Where have you explained the delay?
The para number 6. Of main petition.
Para number 6 of
Delay condonation petition.
yes, para number
Para number 6 of
of the condonation of delay.
condonation petition.
Why the delay was there?
Actually, your lordship, after passing the judgment and award, some procedure have to follow to file the appeal. In the meantime, the judgment and award obtained by the counsel of the petitioner
Okay,
and submit.
heard Mr. What is
HP
your name?
HP Pukon, lordship.
Heard Mr. H. D. Fukon, learned counsel for the applicant. None appears for the respondents, though it appears from order dated 30/7/2024 that notices were duly served on all the respondents. Stop. As no one has appeared for respondents, this court intends to proceed ex parte against all the respondents in this interlocutory application. This interlocutory application has been filed under Section 5 of the Indian Limitation Act 1963 by the applicant insurance company praying for condonation of delay of 138 days in preferring the connected appeal. What is the procedure here? The appeal is registered
Appeal is registered.
before condoning the delay.
Yes, Your Honor.
What was the
There
line,
was a-
last line? 138 days in preferring the connected appeal. That is MAC appeal number 6 within bracket AP 2023, whereby the judgment and award dated 31/5/2023 passed by the Motor Accident Claims Tribunal, Alo, West Siam, in MAC case number 2/2020 has been impugned. Learned counsel for the petitioner has submitted that since the petitioner, instead of petitioner, applicant, right, everywhere applicant. Since the applicant is an insurance company, it has to take administrative approval before preferring appeal against the impugned order. And the administrative approval has to be taken from the regional office Guwahati.
Yes, sir.
And during the administrative process, the delay has been caused, which is bona fide and was not intentional. Stop. I have considered the submissions made by learned counsel for the applicant. Considering the submissions made by learned counsel for the applicant, as well as considering the reasons shown for the delay in paragraph number 6 of the condonation of delay application, this court is of considered opinion that the applicant has sufficiently explained the cause for delay in approaching this court in preferring the connected MAC appeal. Application is allowed and the delay of 138 days in preferring the connected MAC appeal is hereby condoned.
Your lordship, you have filed another application for stay of
No,
approved judgment.
just let us first issue notice to.
As because your lordship,
In MAC appeal 6, in view of MAC appeal 6, in view of the order dated 19/8/2024 passed in IA within bracket C number A 180 within bracket AP 2023, whereby the delay of 138 days in preferring the instant MAC appeal was condoned. This appeal is admitted. This appeal under section 173 of the Motor Vehicles Act 1988 filed by the appellant insurance company impugning the judgment and award dated 31/5/2023 passed by the Motor Accident Claims Tribunal ALO, West Siang in MAC case number 2/2020 is hereby admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice to all the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly. Yes. Now what is there? IA is there.
I is here.
Where is that?
181, your lordship. I civil 181.
What was the award?
Award, your lordship, 30 lakhs.
You pay 50% to the registry. Deposit
Actually,
50%.
Actually, there was a huge calculation of award in the judgment.
Wrong calculation.
Wrong calculation.
How much
Yeah.
it should be?
It should be, your lordship, around 12 or 13. There was a
What is the wrong calculation?
default interest also imposed.
Thank you. Now, what ground you have taken in the MSc appeal? Why you have?
Actually, we heard this appeal, there was a interest, a default interest imposed at the rate of 12% per annum from the date of judgment and award. If the petitioner will not pay awarded amount within 16 days, 60 days, we have to pay around next 12% interest per annum from the 60 days of the passing the judgment and award.
Okay.
And there is in the judgment, no evidence found about rash and negligence. In the judgment, para number 11.
No, whether any execution.
Execution, they have filed execution, your lordship.
Then you have to deposit some amount. Not without depositing, we are not staying.
Yes.
You are insurance company.
Yes, your.
You deposit some amount, 50% amount to the registry of this court. Or we will issue notice to the.
Okay, we'll depositing the amount.
You will deposit 50%. Then we may stay.
We have some time, your lordship,
How
around
much time?
45 days or 50 days.
55 days, that means 6 weeks. Okay, heard Mr.
SP Pukon. That's it.
SD Fukon.
SP Pukon.
HP Fukon, learned counsel for the applicant. This application has been filed by the applicant insurance company for stay of execution of the judgment and award. Judgment and award dated 31/5/2023, passed by the Motor Accident Claims Tribunal, Alo, West Siang. During the pendency of the MAC appeal number 6 within bracket AP/2023, which has been filed by the present applicant, impugning the aforesaid judgment and award. Learned counsel for the applicant has submitted that the applicant's insurance company has impugned the aforesaid judgment and award on the ground that though the claimants have failed to prove rash and negligence of the driver of the offending vehicle,
Yes, sir. What's it?
same was not considered by the Motor Accident Claims Tribunal while awarding the impugned compensation in favor of the claimant. It is also submitted by learned counsel for the applicant that there is some wrong calculation of interest
Yes, that's it.
in computing the total awarded amount. Stop. He also submits that on a specific query by this court, he submits that the claimants have already instituted execution case for executing the impugned judgment and award, and the insurance company is ready to deposit 50% of the awarded amount if the execution of the impugned judgment and award is stayed. Considering the submissions made by learned counsel for the appellant, the notice to the respondents is hereby waived, and this interlocutory application is allowed by staying the execution of judgment and award dated 31/5/2023, passed in MAC case number 2/2018 by the Motor Accident Claims Tribunal, Alo, West Siang, during the pendency of connected MAC appeal number 6 within bracket AP/2023, subject to payment of 50% of the awarded amount by the applicant insurance company to the registry of this court within a period of not payment, subject to deposit of 50% of the to the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Item number 14. Lordship, this application is transfer application. Lordship. Transfer of the case from Sessions Jurisdiction of Bomdila to Tezpur.
Tezpur,
Yes.
interstate.
Interstate, Your Lordship. Your Lordship, in fact, I had made on the previous occasion, I had made an objection with regard to maintainability, Your Lordship. However, during my research, I had come across a judgment of the Honorable Supreme Court in which the case was between the state of Assam and Nagaland, Your Lordship. Now, in that case, it was clearly given that in a unique situation like the state of the state which are under the benches, High Court benches, Your Lordship, it can be transferred, Your Lordship, interstate. However, if we take into consideration the High Court, Your Lordship, this case has to be transferred to the principal bench, Your Lordship, to decide on the merit, Your Lordship.
Why?
Your Lordship will, if I may, I had just asked my clerk to print it out, but then he seems to leave the premise, Your Lordship, if I may take, Your Lordship. Now, during the detailed discussion, Your Lordship, Your Lordship will see the paragraph 2, Your Lordship.
Yes.
If I may read, Your Lordship. The Supreme Court, the sole repository of the power in terms
Para
of
two.
section. Para 2, Your Lordship.
Para 2 is an issue pertinently.
No, Your Lordship. Oh, I deeply apologize. Para 3, Your Lordship. It starts as shortly put the issue.
Yes.
Your Lordship, the only difference between this case is that it was under CPC, Your Lordship. Now, section 24 and 25 of CPC is in parametry with section 406 and 40 of the CRPC, Your Lordship. Now, if I may read, Your Lordship, the Supreme Court, the sole repository of the power in terms of section 25 of the Code of Civil Procedure to direct transfer of a suit, appeal, or other proceeding from a civil court in one state to a civil court in another state? Or is it open for a high court if it is for the common high court for 2 or more states to entertain an application for transfer under section 24 of the CPC and transfer a suit, appeal, or other proceeding from a civil court to another civil court, both of which are subordinate to such high court but situated in different states, in relation to which it exercises jurisdiction for consideration and the decision?
What was the finding?
Your Lordship will find the finding at paragraph 48, Your Lordship.
Yes.
48, Your Lordship. In view of the aforesaid discussions, the issued answered by concluding that a true and proper interpretation of section 25 of the CPC lead us to the conclusion that the same applies to interstate transfer of a suit, appeal, or other proceeding where both states have a high court in terms of Article 214 of the Constitution, and not to transfer where both states have a common high court under Article 231 thereof. Second, the power under section 24 of CPC can be exercised by the High Court even for interstate transfer of a suit, appeal, or other proceeding if it is the common high court of for 2 or more states under Article 231 of the Constitution, and both civil court transferor and transferees are subordinate to it, Your Lordship. 24 in CPC is with regard to the power of the High Court to transfer, Your Lordship, and 25 is with regard to the power of the Supreme Court to transfer, Your Lordship.
And in case of
CRPC, Your Lordship, it's a parametry, Your Lordship.
407.
406 is Supreme Court, power of the Supreme Court, Your Lordship. 407 is the power of the High Court, Your Lordship.
So same principle would be
Same
applicable.
principle will
So
apply.
this court has the power.
This court has the power. Now, my next submission is, Your Lordship, why this case has to be before the principal bench. Your Lordship will find at paragraph 17, Your Lordship.
What is the citation?
This citation, Your Lordship, AI 2023 SC 1338. 1338. Your Lordship, if Your Lordship will kindly peruse para 17, Your Lordship. Para 17, Your Lordship. my submission with regard is that though it's a bench, Your Lordship, however, this case ought to be placed before the principal bench. And my submission is with regard to, it starts from para 17, Your Lordship. And the conclusion comes to at paragraph 24, Your Lordship. If I may read, Your Lordship.
Yes.
Hence, today the Guwahati High Court is the common High Court exercising jurisdiction throughout Assam, Nagaland, Mizoram, and Arunachal Pradesh. A fortiori or civil courts in these 4 states are subordinate to the same High Court, that is the Guwahati High Court. Thus, it is a High Court which earlier exercised its jurisdiction over 7 different states and is presently exercising jurisdiction over 4 different states. This by itself is a unique feature which stands unmatched in the judicial annals of the country post-independence. We take judicial notice that judges of the Guwahati High Court in the past have been elevated from amongst advocates and judicial officers hailing from the aforesaid states. Therefore, so far as the judicial administration is concerned, in terms of Article 231 of the Constitution, the Guwahati High Court is a High Court, inter alia for the state of Assam as well as for the state of Nagaland. So when I come to paragraph 26, Your Lordship will see there is only one High Court, that is Guwahati High Court, which is the High Court for all the all other 4 states, Your Lordship. So if I read 407 of the, there is only one High Court, that is Guwahati High Court, Your Lordship. If I read 407 of the code, Your Lordship, it states power of High Court to transfer cases and appeal. So when the term High Court is used, Your Lordship, which High Court? The Guwahati High Court, which is a common High Court for all the 4 states. We being the benches, Your Lordship, the power of transfer as per 407 is before the High Court, which originally is the Guwahati High Court, Your Lordship. And therefore, my prayer for transfer of this transfer petition before the principal bench.
No. What is the logic for sending it to principal?
Yes, Your Lordship. Your
Because
Lordship.
this is also Guwahati High Court.
Yes, it's a bench, Your Lordship. With regard to bench, it's already clarified here, Your Lordship, that it has a common High Court, Your Lordship. Now, when we see that the judgment, it says that Guwahati High Court is a common High Court for state of Assam, Mizoram, Arunachal Pradesh, Your Lordship. Now, if we take, Your Lordship, when we read 407, it says power of High Court, Your Lordship. There is only one High Court, Guwahati High Court, Your Lordship. We being the outlying benches, Your Lordship.
No, you mean that this is something separate from?
No, not in that regard, Your Lordship. When I states that, if I may read again.
Any order is passed by this bench, it is order of Guwahati High Court.
Guwahati High Court only, Your Lordship. But then issue with regard
And
to.
how are you distinguishing between principal seat and Itanagar bench?
Because when the question comes to intrastate, Your Lordship, the only code, it states that Guwahati High Court, Your Lordship. We being
So
the
this is also Guwahati High Court.
Yes, Your Lordship. But then
Why it is to be transferred?
to the principal, because the principal, since we are the benches, Your Lordship, the benches is with regard to the jurisdiction
This
only
logic-
set. No, Your
This
Lordship.
Logic is.
My logic
has to
to
be-
that.
You are indicating in somehow that principal seat is on a higher platform.
Not on a higher platform, Your Lordship.
Then-
My logic with that regard is to, when a benches of a High Court is divided, Your Lordship, benches is divided only with regard to certain jurisdiction of a state, Your Lordship. We are dealing here with intrastate, Your Lordship. So this court has a jurisdiction over Arunachal Pradesh, though it's a bench of the Guwahati High Court, principal bench, Your Lordship. Now the principal bench has the jurisdiction over state of Assam, state of Nagaland, state of Arunachal Pradesh. So it can deal along with the cases of jurisdiction of all the courts.
There you may have some.
Yes, Your Lordship. My only submission, and therefore my submission was with regard to paragraph 26.
Yeah,
26, Your Lordship.
26 of the judgment.
Yes, Your Lord. If I'll just read.
You read.
Yes, Your Lordship. Therefore, so far as judicial administration is concerned, in terms of Article 231 of the Constitution, the Guwahati High Court is the High Court inter alia for the state of Assam as well as for the state of Nagaland. So, principal bench is the High Court for all the states having jurisdiction of their own, Your Lordship, but then under the wings of the principal bench.
Yes. What is your submission?
Lordship, first of all, I would submit that the case is registered at Bomdila, which is a part of Arunachal Pradesh. In this respect, Lordship, already Itanagar permanent bench has been created to settle the case connected with Arunachal Pradesh. First of all, and this court is a part of Guwahati High Court. And because when it is part of Guwahati High Court, under the CRPC 407 of CRPC, this court has the power and jurisdiction to apply the 407 CRPC. Power and jurisdiction. The principal bench has only the administrative jurisdiction. Therefore, may it be the trial of the case or transfer of the case, this court has the power and jurisdiction to, being the Guwahati, part of the Guwahati High Court, can transfer the matter to Tezpur. That is why I have filed this application under 407 series. As per CRPC, since this honorable court is exercising 407 CRPC, this court can have the jurisdiction to apply the 407 CRPC. In that event, this honorable court has enough jurisdiction and power to transfer the case to Tezpur from Arunachal to Tezpur.
No, here the actually question which is raised before us is whether the Supreme Court said that in case of a common high court,
Yes.
the common high court can transfer case from one state to other if both the states are within its jurisdiction. But here the question is whether Itanagar bench of Guwahati High Court does have jurisdiction over Sonitpur, that is state of Assam or not.
That is
The submission of your additional public prosecutor.
Additional public prosecutor.
What's your name?
Tijini, Your Lordship.
Yes. The submission is that Itanagar bench of Guwahati High Court does not have jurisdiction over state of Assam, but the principal seat has the jurisdiction over state of Assam as well as Arunachal as well as other 4 states. Now, on what basis you are saying that principal seat has jurisdiction over all the states?
Your Lordship.
After coming into
Yes, Your Lordship. Your Lordship, when I had pointed out
after creation of permanent bench also,
yes, after creation,
still principal seat does have jurisdiction over all the 4 states.
all the 4 states, Your Lordship. Because since
Therefore,
our High Court has this unique
therefore, this transfer petition
ought to be
have been
placed before the principal bench.
principal bench.
Yes.
There seems to be logic.
Lordship, everything is for education of justice. If that is the case, Lordship, can this matter be transferred to principal seat? So,
Yes,
for further hearing of the case.
we are transferring it to you. I need that judgment.
I'll be giving it right now, Your Lordship, with the relevant paragraphs. I'm relying on Your Lordship.
Then-
In fact, I was to be printing the same, Your Lordship, but that
Then
clerk
I'll
had-
pass the judgment in my chamber
Yes,
after going through.
Appropriate.
that.
yes, yes.
I'm transferring this.
Yes.
This matter to be placed before Chief Justice,
Yes.
whether principal seat should take it up or not. With that recommendation, I'm
Yes.
sending it to principal seat. You give the copy of that.
Yes. Deeply.
Item number 50.
Your Lordship, we have received the Elsa record, law court record. This is a jail appeal, Lordship.
Who is for the appellant?
Lordship, P. Tapo was there in the morning, Lordship.
It will go for hearing only.
Lordship. The Elsa has come, Lordship, so it may be posted for hearing. Lordship, I want.
None appears for the. No, learned amicus curiae, Mr. P. Tapo was not found on call. Heard Miss L. Hage, learned additional public prosecutor for the state of Assam. It appears from the office note dated 18/7/2024 that the trial court record has been received by the registry, and this case, no, the paper book would be
Paper book?
required or
Lordship,
not required.
Lordship, if for the convenience, Lordship, because we
Because
could
he
not
can-
go through, Lordship. Otherwise, Lordship, the Xerox copy of the our record, Lordship, may be furnished to both of us, Lordship.
Furnishing Xerox copy would do.
No, it won't do, Lordship, because Lordship, everything is here, Lordship.
Let the copy of
Yeah.
LC, the trial court record.
Scan copy of the trial court
Let the
record.
scan copy of the trial court record be furnished to learned additional public prosecutor
As well as the.
to learned amicus curiae.
Yes.
Thereafter, list this matter for hearing
Lordship. After 2
In-
weeks, Lordship.
after 2 weeks
Lordship.
by the registry.
Lordship. Obliged, Lordship.
Item number 80. Lordship, in this case, interlocutory application for application for delay condemnation, there is a serious defect in the case. So I have filed correction application today. That will be fixed after on the next Monday.
Defect, where the defect is,
Lordship, in the cause title, instead of Limitation Act, he has written as Code of Criminal Procedure.
heard Mr. T. Tapak, learned counsel for the petitioner, learned counsel for the applicant / appellant. Also heard Ms. T. Ginny, learned additional public prosecutor. Learned counsel for the applicant appellant has submitted that some inadvertent typographical mistakes have crept in the interlocutory application filed by the applicant for condonation of delay, and to correct the same, the applicant has already filed another interlocutory application today itself. Same may be brought on record. Stop. Considering the submission made by learned counsel for the applicant, let this matter be listed on Wednesday.
Tuesday, Monday is holiday.
Tuesday.
27.
Tuesday will be DP only.
28.
28/8/2024.
Different.
Item number 90.
17, my lord, shall be appearing in this. 17, my lord, shall be appearing in this.
Oh. Item number
My lords is asking me, my lords. I'll be appearing for 17, my lords, for petitioners.
17, we have already passed the orders. An
I take my
adjournment
lord's-
prayer was made.
I
It
take my
was
lord's
called
pardon.
earlier.
I take my lord's pardon. I have not heard. I've been in the court since morning, my lords. I take my lord's pardon.
Okay.
My lords, if my presence is why I'm here since morning, my lords.
What's your name?
Hazim Qureshi, my lords.
Show the name of Hazi Qureshi, learned counsel for the
Petitioner, my lords.
petitioner in item number 17.
My lords, there's an
We
interim
are
as well.
showing your name in the
Yes, my lords, there's an interim as well.
interim shall continue.
My
Interim
lords
shall
have fixed
continue.
any date in that?
It is fixed on 5th of September.
My lords, I take my lord's pardon. 5th, my lords, won't be possible for me. My lords, there's a POXO bail application listed before the Honorable High Court of Jammu and Kashmir, my lords. I have to argue in that, my lords. If my lords, a date is some
No,
other date
we,
is.
we cannot change the date. Now you were not on time. Though
my lords,
you came
I
through VC.
take my lord's
You
pardon.
should have linked.
I take my lord's pardon, but my lords can just see when I have joined. I have joined since my lords was holding the division bench, my lords. I was going through the proceedings of the division bench as well. Then when my lords hold the single court, my lords, I was from the very beginning
No.
here. I take my lord's pardon, my lords. It's my apologies, my lords. But my lords, my client will suffer is if this is fixed on 5th, I won't be able to appear before my lords.
No, just a minute. We will take it up your matter after this matter.
Please, my lords, please, my lords.
This is item number
19.
19. Let me.
Okay.
Here. Item number
Please,
17.
please, my lords, please.
We will take it. Yes, Mr.
Please,
Ite.
please, my lords.
We'll take up your matter again at 3:30.
Please, my lords, please.
Yes, call other matter.
Lordship, as per office note dated 17/6/2024, Lordship, service report against respondent number 2 is still awaited, Lordship. Lordship.
Not POXO matter, your lordship. It's
So what is to be done?
PDPP, your lordship. Await
service.
await service report, your lordship.
Heard Mr.
K. Lawrence, Lordship.
K.
K. Lawrence, Lordship.
K. Lolin, learned counsel for the petitioner. Also heard Mr. T. Ete. Learned additional public prosecutor. It appears from the office note dated 17/8/2024 that service report in respect of notices issued to respondent number 2 is awaited. Await further. Let this matter be listed again after 2 weeks. On a date to be fixed by registry.
Lordship, there is an interim order.
The interim order shall continue till next.
Deeply obliged.
May I please along? Here, my lord, this is application for cancellation of actually bail. That is
Cancellation of-
challenging the non-application of mine, my lord. So we have received the affidavit in opposition filed by the respondent number 2. And my lord, on 12/8/2024 order,
Whether case record was called for.
case record was called for. Up to that case record was called for. Therefore, my lord, this case is ready for my lord admission hearing. May I pray that lordship may fix this case on 27 of this month for admission.
27 is Tuesday.
Monday, Tuesday. And Monday is
Tuesday-
Milord Janma
No, this week, next week, Tuesday will be only DB matters will be taken up.
Then on 28th, Milord. As a fixed item. Here, my lord, we are
Whether
Karen
trial,
482.
the up-to-date records have arrived,
Your Lordship. The record, Your Lordship.
records have arrived. Heard Mr.
Amazon.
Mboje, learned counsel for the petitioner, also heard Ms. T. Ginny, learned additional public prosecutor, as well as
Respondent number 2,
Mr.
Rupti Chitara.
T.T.
Arti Tara. Arti Tara.
R.K. Tara, learned counsel for respondent number
2.
Respondent number 2. The updated record of the trial court have been received by the registry. We'll admit it and fix it for hearing.
Yes.
Today we'll admit it
Yes.
and fix it for hearing
Fine.
on
28th.
28th. This criminal appeal is admitted. Stop. As the matter is ready for hearing, place this matter again on 28/8/2024.
Well. Most of it.
What is this?
My lord, this IA has been filed for condoning a delay of 488 days, Your Lordship, in filing a connected
For 18 days.
488 days, Your Lordship, in filing a connected interlocutory application for implement of the applicant as the sole respondent.
Appli- No, for this
IA has been filed
for condoning the delay
yes,
in
for
filing another
IA, yes, Your Lordship, which is for implement
treatment of
the applicant as the petitioner, Your Lordship, in,
treatment as petitioner.
yes, Your Lordship.
Why? Where is the original petitioner?
He was the father of the applicant, Your Lordship, and he has passed the. Substituting.
Then it has to be substituting.
Yes, Your Lordship, he is substitution, Your Lordship. I'm sorry.
You have any objection?
No.
Heard. Miss D. Panging,
Tamuk, Your Lordship.
D. Tamuk, learned counsel for the petitioner. Also heard Mr. T. Tapak, learned counsel for the respondent. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of 488 days in filing the connected interlocutory application, whereby you have used the word impediment
Yes, Your Lordship, that's been wrongly. I'm sorry, Your Lordship.
because
but
there is a difference between
Yes, Your
Order
Lordship.
1, Rule 10 and Order 22,
Yes,
Rule
Your Lordship.
3.
But then, Your Lordship, we had reflected the right provision, but however, the word had been wrongly used, Your Lordship. It has to be substituted.
For substitution,
Yes, Your Lordship.
stating the legal heir of the original in the SAO within bracket civil number 1/2020. Where have you explained the cause?
My lord, in paragraph 4 and 5, your lordship.
Learned counsel for the applicant has submitted that the applicant was prevented from approaching this court within the period of limitation for the reasons mentioned in paragraph 4 and 5 of the condonation of delay application. Stop. Mr. T. Tapak, learned counsel for the respondent, has not objected to the prayer for condoning the delay. In view of the above, considering the submissions made by learned counsel for the parties, as well as reasons mentioned in paragraph number 4 and 5 of the condonation of delay application, this court is of considered opinion that the applicant has sufficiently explained the delay caused in preferring the substitution petition by the applicant. Stop. Hence, this application is allowed and the delay of 488 days for preferring the substitution application by the applicant is hereby condoned. This interlocutory application is accordingly disposed of. Next, I-131, heard Miss D. Tamuk, learned counsel for the petitioner, as well as T. Tapak, learned counsel for the respondent. Here also you have filed order 1 rule 10.
Yes, your lordship.
It should have been order 22
22, your
rule
lordship.
3, because you are coming in place of your father.
Yes, your lordship.
Your father expired, therefore you are coming. So it is not a case of impleading. It is case of substituting. You rectify this.
Yes, your lordship.
Rectify this, we'll fix it on,
Day after tomorrow, your lordship.
fix it on Tuesday.
My lord,
Wednesday or maybe Thursday, Friday, any.
in
This
case,
week
your lordship.
itself.
Yes, your lordship. Day after tomorrow in that case, your lordship.
Yes, day after tomorrow. Learned counsel for the applicant submits that there is unintentional typographical error in the cause title of the application, which the applicant intend to rectify by filing an what is the procedure?
My lord, and I has to be filed for rectification.
Filing an interlocutory application for amendment of the cause title of the present interlocutory application. The prayer is allowed. Let this matter be listed again on, what is day after tomorrow? 21/8/2024. In the meanwhile, the petitioner may file the interlocutory application as desired by him. List accordingly.
Yes, your lordship.
Who controls the VC? After this item, we'll take up that. No, I'll make, I have given him about 3:30. If it for 3:30 immediately after completion, or otherwise at 3:30. Yes, Mr. What is your name?
A Hussein.
What is this?
My lord, let's see the page 41. I am against this order. This is the Zimma petition order. Today the case is fixed for hearing. The IU has commented that now a total amount of rupees 36,33,857 only is in the account
No,
number.
what is the matter? What,
Matter-
Jimma of what matter?
Zimma against the order dated 26 JMFC. And let's see the page 41 is the order, Zimma order. 41.
No, what is this? Jimma of what?
Zimma, in Zimma petition, the respondent number 2, Norong Rikom, claimed that the amount mentioned 36 lakhs 33,857 is his amount. And court, without hearing me, order passed and amount has debited from my account. And
It has already been debited.
already debited.
Then what is your prayer in this case?
Now my peer kindly matter may fix for hearing and kindly give a direction. No further amount shall be debited from my account.
You have just now submitted that already the amount has been debited. Then where is the question of further? My query is whether this 36,33,857 has already been debited.
Yes, madam.
Already been debited.
Already debited.
Then
And credited in the account of the Noram account.
what is your prayer in this
My
case?
peer now some other amount is available in my account.
But
FD,
for other amount, there is no order.
maybe they will come again
No.
file, they will Zimma
Then you-
petition, they will claim that amount again order will pass.
When you appear before the trial court, this amount was in respect of which case?
In
120
Naharlagun PS case number 14. Paragraph 2 is the FIR, my lord. Details of the FIR, paragraph 2.
What relief are you seeking? To
My lord-
return back that amount
Yes, my lord.
or for setting aside that
Yes,
order?
my lord.
You have to make your submission. I will not make submission on your behalf. You
My-
know your case.
My submission is that, my lord, the amount which is debited from my account to the account of the respondent number 2 is not the account of the respondent number 2.
Is not the money.
It's
of
not the money of the respondent number 2. Now, money, I want to refund my money, and further the amount now 14 lakh something is available in my account. That amount FD, fixed deposit amount, has matured. They will claim again and file in my
They
petition.
have not claimed yet.
Maybe they tomorrow they will file.
Then you come tomorrow. How on anticipation, what application they will file, this court can pass an order. This way. Here your prayer is setting aside the impugned order. We are issuing notice. Your ground for setting aside is that you were not heard. That
Yes.
is the ground. Any other ground? What is the case?
Is paragraph 2, my lord, I have mentioned. FIR was lost by respondent number 2 that I, along with some other persons, has looted an amount of rupees 3 crore in cash.
Looted?
Yes, my lord.
Okay.
Cash, my lord.
Then we are issuing notice. Heard Mr.
A. Hussain.
M. Hussain, learned counsel for the petitioner. What is section 438?
438, my lord. High Court power of revision.
Then revision and 528 cannot come together.
Yes,
You
my
have
lord.
to- It has to be either
528, 438, 442. Read with section 528.
You cannot read with 528 with everything. Either it is revisional jurisdiction or where is the impugned order?
Page 41.
When it was passed. Heard Mr. M. Hussain, learned counsel for the petitioner. This application under section 438/442 read with section 528 of BNSS 2023 has been filed by the petitioner impugning the order dated 26/2024 passed by learned Judicial Magistrate First Class Capital Complex UPI in JIMA application number 26/2024. Arising out of Naharlagun PS case number 14/2023 corresponding to GR case number 55/2023. Whereby the JIMA application filed by the respondent number 2 was allowed by the trial court. Also heard Miss P. Ginny, learned additional public prosecutor, who appears for the state of Arunachal Pradesh, issue notice to the respondent. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to the said respondent. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on which date? 30. No. Returnable on 30/8/2024 or 31/8/2024.
Lordship may also call for the scanned copy of the record.
Let the scan copy of
My lord, in the meantime, my account can be protected.
no, there is no indication that your own submission is there. Let us peruse. JIMA petition has already been allowed.
Yes.
There is no pending JIMA petition.
Yes, ma'am.
Then why should we pass any order? Where is the apprehension? There is nothing pending against you.
Yes.
No, so it does not call for an interim protection. Let this matter be listed accordingly on the, no, let the scan copy of be called for from the trial court, registry to issue requisition for these scan copies. List this matter accordingly on 31/7/2020. 31.
One is Saturday, Your Lordship. If Your Lordship thinks this matter.
My lord, 30 will be there.
2nd of September.
No, second of September, I have some problem. Yeah.
This Saturday is a working day, 31 is a working day.
Yes.
31 will be better.
Deeply.
Hopeless.
What happened?
My lord, contesting counsel for the respondent, Your Lordship, Mr. D. Pandyan is out of station. Can the matter be listed after 2 weeks?
No, what, for what stage this matter is pending? Hearing?
Yes, Your Lordship.
Now, what is the submission?
My lord, contesting counsel, Mr. Pandyan is out of station. Your Lordship.
Okay. Any objection?
No objection, Your Honor.
Heard, Miss, what's your name?
D. Riba.
Heard, Miss D. Riba or
Riba.
Riba?
RIBA.
Riba, learned counsel for the
Petitioner.
appellant. Also heard Miss
D. Tamuk, Your Lordship.
T.
Tamuk.
T. Tam. K. T.
No, Your Lordship. D. Tamuk.
T. Tamuk. T or D?
D.
Delhi.
Delhi. Yes.
D. Tamuk, learned counsel for the respondent, who submits that the Mr. D. Panging, who is the conducting counsel for the respondent in this appeal, is out of station and therefore prays for an adjournment on that ground. Learned counsel for the appellant does not opposes the prayer, hence the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Much obliged, Your Lordship.
Item number 17.
17, my lord, sir. 17 called, my lord.
Sir, morning lordship, this matter is taken adjournment by the respondent lordship, respondent party. It's already been fixed on 5/9 lordship.
Where is the order?
I'll be only requesting for the change of date, my lords, if my lords will allow.
No, but the counsel for the respondent had mentioned before this court that he has taken consent from you.
There's a local,
mentioning.
there's a local advocate as well, my lords, advocate Mr. Tim Pahi, my lords.
Your audio connection is not proper.
I take my lord's pardon, my lords. I totally apologize for that.
No, but
My lords,
it is
local,
difficult to conduct the case through video conferencing is if the connectivity is not proper.
then my lords
I'm
may,
not getting.
then my lords may kindly permit me to appear physically before the honorable court. Then can my lords fix it in the month of October, if my lords possible? I can physically come before the.
No, but now the counsel for respondent who appeared on that day.
Please, my lords.
Is not present. Who
Please,
made the mention in the morning?
Mr.
is
N.
not
Rama,
present.
my
On
lords.
5th, it may be arrived lordship. On that day, he can mention lordship.
You can do one thing on next date, that is on 5th of September.
Please,
You
my
may
lords.
make a mention. You may
Please,
make
my
a
lord.
mention.
Please, my lords.
And on that day, you may take a suitable date.
Please, my lords, as my lords.
Mention after informing the other side. Other side
Please,
will
my-
be present on that day.
He will be
Please, my
present,
lords.
lordship, because he himself, other side himself,
Yes.
yes.
Because
fix the
that
date,
is the
lordship.
best option.
Please, my lord.
So
Then
we
my
are
lords may
we are not-
kindly extend the interim, my lords.
Yes, interim shall continue
Please, my
till
lords.
next day. इसमें अमिता एक लाइन ऐड करना and show the presence of Mr.
Hazim Qureshi, my lords.
Hazib H. Qureshi.
Please, my lords.
Interim shall continue till next. One case Miss Jenny will give.
Highly obliged, my lord. Thank you.